status report, my lord. But my lord, my only prayer, my lord, is tomorrow at 3:30, my lord. Both I am led by Mr. Rudraman Bhattacharya and Mr. Ranjan Basawat.
So that first let it come, then
Both of them, my lord,
ask
are
for
in some
adjournment.
difficulty tomorrow.
Can bhai 8th May order? Dekho to, this is very serious.
Status report, my lord. My lord, the case data report is with me, my lord. It is not reflected over. But my lord, my prayer is, my lord, for tomorrow at 3:30, my lord, both the learned accounts.
Let it be listed, then we'll see. And please be sure before you make some grievance.
My lord, carrying the case status report, my lord, somehow, my lord, it is not reflecting.
Dekho.
Your lordship's kind leave may be permitted to mention, your lordship, upon notice, your lordship, the suit has been dismissed.
You want inclusion?
Yes, inclusion, your lordship.
If
If
it
it
could
could come up tomorrow, your lordship.
Next, yes.
Lordship, if it could come up tomorrow, your lordship.
Why? What is the grave urgency?
The grave urgency is that the interim order which I was enjoying for about 8 months, that has been vacated.
Very well. Have you filed?
Yes, your lordship.
Give the number.
Lordship, it has been indicated, your lordship.
Once the papers come, it will be listed.
Grateful, your lordship.
Any other mentioning?
Appellate side.
Appellate side.
May I be permitted to mention an appeal which has been earlier referred by Justice Somin Sen bench for mediation, but it was not succeed. So therefore, I bring for accommodate in the daily list.
Therefore, you are asking for?
Accommodate in the daily list for adjudication.
Yes, let it be listed. Give it.
Much.
Appellate side matters, commercial division, item number 1.
Item 1.
Item 1.
Or should kindly keep it after vacation.
You are for the appellant?
I am for the appellant.
Very well. On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed again on June 10.
Item 2.
Item number 2, my lord, we appear for the appellant. Mr. Pratik Mukherjee is appearing online. Is leading me in the matter.
Online has. Online has.
Pratik Mukherjee.
Pass over, nahi respondent nahi pass over.
Five. Item number 5.
I am paying for short passover. Short passover, lordship, I don't know.
6.
My lord, 6. I appear for the appellant in this matter. 6.
Yes.
My lord, I appear for the appellant in this matter, my lord. Now, my lord, there is a talk of settlement which is in process, my lord. So if the matter could stand over, my lord, till the vacation gets over, my lord.
Abhijit, learned advocate for the appellant says that talks of settlement between the parties are in progress. Talks of settlement are in progress between the parties. Stop on his request, let this matter stand over till after the summer vacation and be listed again on 1 week after.
My lord, reopening week only, my lord.
June 10.
There's only one request, my lord, if it could retain its position, because so that if the settlement gets affected, it can be given effect to order.
June 10, retaining its position.
Grateful, my lord. Deeply obliged.
Item 7. Item 7. Item 8.
We are for the appellant.
The appellant, my lord.
Appellant,
Yes.
No, my lord. I am with.
pass over.
Pretending to be the other side.
Yes.
My lord, we have not served on them, my lord. We have
Oh.
not served on them.
So, when?
My lord, I'll tell my lord what's happened. My lord, we filed a suit. My lord, we have a registered access agreement.
You have?
A registered access agreement in respect, my lord, a plot of land. I, my lord, have my factory, my lord, there. And through the plot of, my lord, another one, which, my lord, we have been enjoying, my lord, for last, my lord, several years. We have, my lord, like I said, my lord, access agreement. My lord, we filed a suit, my lord, because they were preventing us, my lord, from
You have access through the respondent's land.
yes. It's, my lord, it's one of the gates because, my lord, initially, my lord, those both plots, my lord, belong to, my lord, one company. Thereafter, my lord, part was sold to us with, my lord, an access agreement. Otherwise, my lord, I don't have a proper access, my lord, from the main. I had a back access, my lord, which was not really, my lord, conducive, my lord, for my trucks to come in, my lord. I am, my lord, Berger Paints India Limited. Now, I filed a suit because, my lord, they were disturbing my access, my lord, after, my lord, several years. So, my lord, I have obtained an order of injunction, but, my lord, the learned judge, my lord, has also, my lord, passed, my lord, an order, my lord, for an advocate commissioner. We don't know why, my lord, an advocate commissioner, my lord, has been order has been passed. When, my lord, I have an order of injunction, so I'm aggrieved, my lord, by that, my lord, on the basis of that. And, my lord, the learned judge also proceeds on the basis of an unregistered agreement, my lord, which is not, my lord, correct, my lord. It's a registered agreement itself.
Serve and come back day after?
What has happened, my lord? Keep on. My lord, that's my lord, the difficulty has been, my lord, in spite of the order which has been passed in my favor, my lord, they still continue to obstruct me. That's,
Then
my lord,
file contempt.
my lord, we have, my lord, a contempt ready. My lord, absolutely correct. My lord, I'm not, my lord,
Serve and come back day after
Will-
tomorrow.
will serve and come back. I think, my lord,
Serve
that's
and come
best. I don't think, my lord, I can obtain, my lord. So, my lord, I wanted a stay of, my lord, the advocate commissioner till, my lord, hears out the matter because I don't think, my lord, evidence gathering, my lord, is.
Day after tomorrow, nothing. will
Yes,
happen.
yes.
Mr. Banerjee, learned senior advocate representing the appellant, says that service is yet to be effected. Stop. Let service be effected on the respondents and affidavit of service be filed on the next date. Paragraph lists the matter. Oi Porshudin. Day after tomorrow?
Day after tomorrow. Only one. No, if it retain, it will retain. my lord.
It will retain. Retaining its
I don't know why. I'm sorry, my lord. I spoke, my lord, because of, my lord, instruction there. I should know.
Is this prompt?
I should, yes, my lord, I should filter, my lord, whatever, my lord, comes in. I'm so sorry. Mr. Sharma, yes. Now, okay, let's go. I'm grateful. my lord.
When are you leaving town? Saturday.
Sunday, my lord, but I'm, my lord, still, my lord, within other jurisdictions. my lord.
Oh, I see.
Oh, holidays, my lord, don't coincide anymore.
All right.
Item 9,
My lord, learned senior advocate Shayantan Basu is leading us in this matter. He's busy downwards parking the car. We are praying
Chalo,
for
chalo,
a
next,
humble
pass over. Pass over.
item 10,
Ship, I appear for the appellant. Ship, the respondent has been served. The affidavit of service is just getting
He's
ready.
appearing.
Lordship.
My lord,
May
I have, my lord, I'm appear for the Union of India, my lord. I have no instruction right away. Just now I got a call from the office, my lord, that to appear, but I don't have any instruction on the
Yeah.
matter, my lord. I don't have the brief also.
May I
right now.
beseech your lordship only on one ground, lordship. There is extreme urgency. We took leave for this matter. It's a very simple point. Lordship will just kindly hear me out and then lordship will decide. Lordship, what has happened is, Lordship, what has happened is I had a tender from the railway authorities to execute a work. I was terminated. I came before the writ court. The writ court gave me a protection and asked them to reconsider their order of termination. In the meanwhile, the protection was in the nature that my bank guarantee and the security deposit which was with them would be kept preserved in a bank account. Lordship, I went, the termination speaking order was passed, which just reaffirmed the termination. I approached the Section 9 court, the learned commercial court at Alipur. Lordship, I obtained an ex parte ad interim order. Thereafter, that interim order was extended at least 5 times in the presence of the respondents. and they sought time to file their objections. At this stage, my lords, we approached because we sent the section 21 notice. There was a unilateral clause that got overruled, and finally, and
So you take instruction,
Yes, my lord.
but immediately we'll grant interim protection.
I'm so
Then,
grateful. That is the only.
My lord doesn't record my name, my lord. Because I don't have
Better.
any instruction.
Lordship.
Better. You file your affidavit of service.
Lordship. Only that protection could be granted. That's all I was praying.
My lord, one point only. In the meantime, the arbitral tribunal has been appointed, my lord. They can approach under section 17 before the arbitration.
Exactly. We can actually dispose this off because what we intend to do,
Lordship.
extend the interim protection for a limited period with liberty to them to
Absolutely.
renew their prayer before the arbitral tribunal.
I bow down.
But doesn't record my name, my lord.
I bow down to that, my lord.
Because I don't have any instruction on that, my lord. Thereafter,
The service filed. They are not appearing. দেখে দেবো? ঠিক আছে। Affidavit of service filed in court today be kept with the records. I দাও তো একবার দেখে নি। Hand service.
Lordship, hands up. I had, pursuant to the leave, I had given a advance copy, and this is the final service that's there. Yesterday.
They don't give any stamp or
Lordship, they
anything.
gave a stamp on the advance copy. The final copy, they refused to give a stamp because there was not 48 hours of time. They said they couldn't, because it's a pursuant to Lordship's leave, they took it, but they did not give the stamp. They gave the stamp in the advance copy.
Very
It's
well.
there.
Kept with the records. Stop. In spite of service, nobody appears for the respondent. Paragraph. The appellant has come up against an order dated May 16, 2025, whereby learned judge, commercial court at Alipur, disposed of Miss bracketed ARB, Com 110 of 2024, without extending the interim order that the appellant was enjoying for quite some time. Stop. Paragraph. The brief facts of the case, as narrated by learned advocate for the appellants,
Appellant, my lords, only one.
appellant, are that the appellant was successful in a tender process and was awarded a contract by the railways. Stop. The railways terminated terminated the contract. Stop. The appellant approached this court in its writ jurisdiction. Stop. The writ court directed the respondent to reconsider the issue of termination of the contract. Stop. Pending such reconsideration, interim protection was granted. No.
Lordship, after reconsideration and speaking order of termination was again passed.
Bank guarantee.
Lordship, it was.
What was the direction of the writ court?
The writ court's direction was till they passed the speaking order, the bank guarantee would be preserved.
Okay.
The day the speaking
Achha.
order came, next day we got the.
কি বললাম? না. Pending such reconsideration by the respondent, the appellant herein was directed to keep the bank guarantee, concerned bank guarantee, alive. Paragraph. The respondent apparently reconsidered the matter and passed a speaking order, reiterating what it had said in the earlier order of termination. Stop. Therefore, the contract stood terminated. Stop. Paragraph in view of.
I'm led by Mr. Anirban Ray. I guess he's trying to.
In view of an arbitration, in view of there being an arbitration clause in the relevant contract, comma, the appellant herein approached the learned commercial court at Alipur with an application under Section 9 of the Arbitration and Conciliation Act, comma, 1996, comma, praying for interim relief in so far as interim protection, in so far as the bank guarantee
Bank guarantee and the security deposit was concerned.
and the security deposit are concerned. Stop. An order, an ex parte ad interim order of injunction was passed by the learned trial court on September 12, 2024, which was extended from time to time on several occasions. Stop. Paragraph. It appears that this court, do you know when this order was passed constituting the tribunal?
Lordship, 13th of May, my lords.
13th of May?
13th of May, 2025.
2025. It appears that Section 11.
Section 11.
Who filed 11?
I only filed.
It appears that the appellant herein filed an application under Section 11 of the 1996 Act before this court. Stop. On May 13, 2025, an arbitral tribunal was constituted by a learned judge of this court. Stop. Thereafter, on May 16, 2025, the matter was taken up by the learned trial court when the impugned order was passed. Stop. The operative portion of the impugned order reads as follows. Paragraph, being aggrieved, the appellant is before us. Paragraph. We are prima facie satisfied that the appellant has an arguable case. Stop. Just because the arbitral tribunal has been constituted, it may not mean that the learned trial court stood denuded of jurisdiction to continue the interim protection that the appellant was enjoying. Stop. Paragraph, we are inclined to continue the interim protection for a limited period of time with liberty to the appellant to make a prayer for further extension or other interim protective orders before the arbitral tribunal. Stop. However, we wish to grant another opportunity to the respondent to appear. Paragraph, there will be a stay of operation of the order impugned, which will revive the earlier order. No?
Lordship, I guess revival.
Extend it, my lord.
The order be extended by my lords.
Very well. Stay of operation of the impugned order. Stop. The interim order that the appellant was enjoying shall continue till May 23, 2025, or until further order, whichever is earlier. Stop. Paragraph, list the matter on May 2022, 2025.
I'm grateful.
Where are you?
My lord, some duty called, my lord. Sorry, my lord.
Only thing, my lords, when my lords recorded that it was concerning the bank guarantee and the security deposit, it also concerned blacklisting. If that what could be
Blacklisting.
blacklisting. That was also one of the prayers
Financial
granted.
bank guarantee, comma, security deposit and
The black-
blacklisting of the
because
appellant firm.
that's all. I'm so grateful, my lords. I'm so grateful.
Item 11,
My lord, I am for the appellant. My lord, in this matter, my lord, your lordship directed to deposit the decretal amount. My lord, the fact is
One
that
second. You asked for some more time.
yes, my lord. Yes, my lord. My lord, my humble prayer is that the decretal amount is 10 lakhs 50,000 and not 58,000 and not. My lord, the appellant managed to deposit 6 lakh 50,000. The rest amount, I am praying if your lordship kindly 2 days time may be permitted to deposit the rest amount. My lord.
Thursday, by Thursday.
By Thursday, I will deposit, and if your lordship kindly direct me to pay by demand draft, that will be convenient for me, my lord.
Whatever. Demand draft is as good as
in
cash.
your lordship's direction was to pay cash or bank guarantee. There was a direction.
How will it help you? Demand draft publicly for cash. How will you get a demand draft if you don't have the cash in your account?
No, actually, the depositing of cash is some. There is some trouble to depositing the cash. If your lordship kindly, if you that to deposit draft, that will be easier.
Very well. We'll keep this on Friday. By Thursday, before that, let them deposit.
My lord.
Read order dated May 8, 2025, paragraph. Learned advocate for the appellant says that you have already deposited 6 lakhs.
6 lakhs 50,000.
Already deposited.
Already.
With the
with the account section.
says that the appellant has already deposited rupees 6.50 lakh with the account section, comma, treasury of the High Court, comma, appellate side, comma, Calcutta. Top. A receipt issued by the concerned cashier has been produced in support of such statement. Stop. This is the original. Give a copy to be kept with the records. Stop. A copy of the receipt shall be retained with the records. Paragraph learned advocate says that the decretal amount is rupees
10 lakhs 58,882.
10 lakh 58,882.
0.70.
0.70 paisa. Stop. The appellant prays for 2 more days to deposit the balance decretal amount. Stop. He further prays that he be permitted to deposit such balance amount in the form of a demand draft. Paragraph. Now let this matter be listed again on last dine date diye dao 23 May. So in the meantime, the appellant shall deposit the decretal amount, balance decretal amount.
My lord, interim order, my lord, is expiring today, my lord.
Balance decretal amount, whether in cash or in the form of demand draft. Whether in cash or in the form of demand draft. Stop. Paragraph. The interim order that is in operation shall continue till May 23, 2025 or until further order, whichever is earlier. It had a copy niye now. So in whose name will it be?
It should be on the name of the Registered General.
That we don't know. We will not extend the order if he is not paid.
Required to be in someone's name.
Yes, that may be a practical problem. Deposit cash, deposit cash.
I will try, man. I will try.
Not sure.
Item 13,
My lord, Mr. Sharathi Dasgupta is in item number 13, my lord. Mr. Sharathi Dasgupta is appealing for the appellant, my lord. He's unwell and could not come to court today. Maybe, my lord.
Tell us what you want.
Maybe after the vacation.
After vacation.
After 20th June, any day. Sir.
After 20th June. On the request made by learned advocate for the appellant, let this matter stand adjourned and be listed on June 23.
I'm good.
item 14,
For the appellant.
Yes.
Swarup Banerjee appearing on behalf of this. I also with him. Only
Can't hear a word of what you are saying.
I am led by Mr. Shatarup Banerjee.
Yes.
He is not come to the. He is not ready to argue this matter. Kindly make it after vacation.
Do not have any objection. Mr. Pronit Baghe is leading me in this.
Mr.
Pronit Baghe.
Pronit Baghe, yes.
He is leading me in this matter, Lordship. If the matter can be kept after the vacation.
He has also gone on holiday.
No, Lordship. He is on lakes at this moment. We are ready to argue with this matter.
So they are asking for after vacation.
We do not have any objection.
On the prayer made on the request made by learned advocate for the respondent, which is not objected to by learned advocate for the appellant, let this matter stand adjourned and be listed again on June 11. You are for the Union of India. He wanted time. He is assisting you.
I was stuck, my lord.
He wanted after vacation. She did not oppose. Her senior is also not available.
Let's see. Their appeal, my lord.
Great.
item 15,
This is my opinion.
Remember, you are for the appellant.
I'm for the appellant. But could I, in a nutshell, appraise the backgrounds a bit before coming to the impugned order?
Irregular allotment.
Yes.
Yes, by that the order we had, our division bench cancelled everything. SLP was dismissed.
Kept outside. Yes.
We were kept outside.
Yes.
Suit had been filed against for cancellation. Because in this case, conveyance had been executed. In the other cases, conveyance had not been executed.
Just to appraise Honorable Justice Rai, my lord,
Yes, please.
in a nutshell, my lord, if your lordship kindly permits, my lord.
Yes.
My lord, this was a case where, my lord, large-scale allotments were made under the chairman's discretionary quota by the erstwhile management of WB HIDCO.
We are hearing the appeal. Let us understand.
Yes, my lord. Because, my lord, the paper books have been filed.
Paper books filed?
Yes.
Oh. Very well.
So, my lord, after the, my lord, change of the political dispensation in the state in 2011, my lord, the present management of HIDCO came to learn that huge illegal allotments have been made in and around that area. So, my lord, decisions were taken to cancel the allotments. But initially, the first meeting of the board of directors of HIDCO which is the 60th adjourned board meeting, was held on the 19th of August 2011, when a decision was taken to cancel, but the cutoff date and which allotments would be cancelled were not decided. There was no decision on that.
Mr. Mitro, we are 2 days, 3 days away from vacation. This will take a little time as we assess.
Yes.
So he will say the worry is that if the respondent creates third-party interest, that's the urgency he will plead. So is it possible for you to take instruction that we'll keep it immediately on the reopening week? Till then, nothing should be done. That is all. We are not in any way restraining you from using it, utilizing it, whatever. Whatever you are doing, go on doing. But just status quo as regards title.
Can I, my lord, take instruction?
Please. Please.
And, my lord,
So that, we can...
your lordship, my lord, I will tell you, lordship, Justice Banerjee knows more than I do. So, kindly keep it as a parted matter, my lord.
No.
I want...
No. This is embarrassing for us for several reasons, which we are unable to say in court. You know it already.
Two matters
Please
I personally really feel bad about not being marked parted by your lordship. One is that issue with regard to my lord Bastu land and whether preemption is
Yes, yes, that was the reference.
And the second matter is with regard to that constitutional tort.
Yes, that was interesting. But sorry, when will you take instruction and come back? 2 p.m. today or? Is otherwise we'll be occupied with this matter for the rest of the day, which is not desirable 2 days from vacation.
Can I come back tomorrow?
Tomorrow? Come back tomorrow? Simply not today. We are not recording anything, but we have expressed our mind. Otherwise, we'll have to hear it.
There was no injunction, my lord. That is why. There was no application of
the suit was pending.
No, maybe. The appeal is pending. The appeal is pending. Same thing.
Anyway, we were not enjoying any.
Pray for it.
Then anyway, it's list pendants, whatever that means.
Whatever is there is
So
there.
please come in the reopening week. Otherwise, reopening week will be relatively lighter. So
Whenever.
Provided Mr. Gupta is back.
Yes, my lord, I am.
no, he'll be back from the south of France, he told me. Yeah.
But unfortunately, I had booked for Turkey, which I had to cancel.
All right then. Hearing of this appeal will take some time. Stop. We are 2 days away from the summer vacation. Stop. Paragraph. Let this matter be listed. Reopening day?
Could it be the day after that? my lord?
June 10?
Yes.
On June 10.
Great.
My lord, I will tell you, lordships, my lord, on a lighter side, my lord, the difficulties of not making matters parted. My lord, in an arbitration proceeding which was initiated in 1987, award was made. Ultimately, the award went before Supreme Court, review section 47. After that, the award was put in execution. It could be put in execution in 2013. Order was made that a special officer shall do this within a particular time. That could not be done for no fault of the special officer or any of the parties. Application for extension of time was heard by one bench, my lord, for 6 days. By another bench.
Extension of time for the special officer to implement the order.
Because, my lord, the judgment debtors continued to make submissions. Another bench by 4 days, by a third bench for 6 days. It's still pending. That's it.
Very well.
No, no, no. A promoter, my lord, comes and says, sorry, I cannot.
But we haven't really heard this matter.
Otherwise, my lord, otherwise, generally, your lordships will kindly, my lord, consider that. my lord.
Yes, kindly.
Because, my lord, it's really,
depending
really
on
bad
the
for the
facts of
client, my lord, having already, my lord, for so many hearings, my lord, and to
So you see, that request can be considered only when a matter is heard at length, has been heard at length.
I'm not saying about this matter.
So we have decided not to hear at length.
Today I made the submission for different reasons altogether.
Yes, we have understood.
Great.
Second call, karo.
Pass over matter, item number 2.
Lord, item number 2, my lord, I appeal for the petitioner. My lord,
Why are you on the virtual mode? Where are you?
my lord, I am in Asansol Commercial Court today, my lord.
If there's disturbance, we will not hear.
No, there's no disturbance. There's one issue, my lord, on the last occasion also, my lord. There was
Hey,
issue with the
respondent to
service. Now, that is the issue, my lord. The issue is the
Yeah, no.
respondent. My lord, service was affected. My lord, it is coming as dispatch till 17th of this month. But unfortunately, I'll tell you, my lord, the brief history of this matter.
No,
Your
no,
lordship.
brief history. I देखी तुम्हें. No. একবার চোখে চোখটা বুলিয়ে নি অর্ডারটা।
But I have inquired, my lord, till 17th, my lord, it is only showing as dispatch.
না এটা আমি পড়িনি। বিরাট লম্বা জাজমেন্ট।
No, the issue is very short, I'll tell your lordship. Very short issue, my lord. The court proceeded. May I just, it's a section 9 application preferred by me. The court rejected it on the want of jurisdiction. My lord, the court proceeded on the principle that section 11 and section 34 are to be heard by courts having the jurisdictional seat. But my lord, that law is not applicable in respect.
This is the problem.
Section
No.
9, section 9, my lord, proceeds on his deemed rate of jurisdiction.
Yes, what are you saying?
And only one thing, my lord. Your lordship in the last order directed us to solve on both the respondents. One of the respondents, with respect to the first respondent, the service is complete. With respect to the second respondent, on the day the order was passed, that is the 8th, my lord, we had dispatched, but till date that has not been. Today morning we have taken out a report; it has not been complete. So, my lord, I was only beseeching your lordship to keep it just after vacation, because by that time the second
Very well.
respondent would also be served.
Very well. Service is still not complete.
With respect to
Service
the
is
second
still not
respondent.
complete. Stop, as fairly suggested by learned advocate for the appellants. List this matter immediately after the summer vacation on reopening day.
Day after, my lord.
Yes, my lord, on the reopening day.
June 10.
June 10th.
So on that day, fresh affidavit of service will be filed in court.
By that time it will go, my lord. In Jharkhand.
Grateful to your lordship, my lord.
Grateful, my lord.
Sorry, my lord, I had to appear online, my lord.
Come back.
Yes, my lord. Grateful to your lordship.
Item 5.
Morning. I am for the appellant, my lord. The appellant come here, my lord, against the ex parte interim order passed by the learned commercial court, Rayahat, my lord. The plaintiff respondent, my lord, sold his 1/7 share to the subject matter of the property to us, the appellant, and rest of the co-owner, my lord, entered into a development agreement with us, and on the basis of the development agreement and on the basis the strength of the, my lord, sale deed, we started construction. When we started construction, my lord, the, my lord, plaintiff filed a suit, title declaration suit, before the learned court of Barashat.
Why haven't you approached the learned trial court for vacating?
My lord, why, my lord? Because earlier they moved this honorable court. This honorable court, my lord, protected them by an order. wherein I deposited 10 lakhs before the learned court below. He is already protected, but simultaneously, my lord, he approached the commercial court and
Correct.
got
So the
interim order.
commercial court has passed an ex parte order.
Yes, my lord.
Go and ask for vacating that order.
Yes, my lord.
Why should
I
we
know your
interfere?
view, your lordship view.
Yeah, absolutely. If you know that, then why are you troubling yourself so
The
much?
client, my lord.
Right. So we will formally reject it, granting you liberty
Yeah,
to
my lord,
apply
kindly
for vacating.
approach, my lord, kindly fix date. Otherwise, this matter will not be heard.
Very well. We'll do this.
Yes.
We'll pass direction for exchange of affidavit within stipulated period and request the trial court to dispose of this application, preferably within, let us say, 3 months or 4 months, whatever.
Because what happened, my lord, in the meantime, we my lord, complete the my lord, block 1, block 2 already completed. We are not able to transfer. Well, because of interim order passed by the my lord,
Very well.
commercial
We'll eclipse the time period, shorter time
My lord,
period.
my lord, I am for the respondents, my lord.
Yes,
My
what?
lord, may I am for the respondents, my lord. My lord, whatever has fallen from your lordship, my lord, I also want your lordship kindly expedites the hearing of the injunction.
Yes.
application. But my lord, before that, my lord, only one thing, my lord, I may draw your lordship's attention to the next order. After that,
Why,
lord-
sir?
my lord,
We are
because-
not entering into the merits of the case at all.
my lord, just only to suggest your lordship one thing, my lord. They have been served with the plaint and the injunction application on the by compliance of Order 39 Rule 3 and 3B, and by that virtue only they have filed the appeal before your lordship.
Yes.
Now, my lord, on the next date they go before the learned trial court and say that we have not been served with the plaint and the injunction application before the trial court, my lord. The trial court orders records that. So, my lord, with this, my lord, may I humbly submit.
So
with
you
these
are
valid-
saying they are naughty boys.
with this reality tactics, how will they?
Your other side is always will be a naughty boy.
Well, this thing may only be recorded, my lord.
Yes, to satisfy the learned court below about the compliance of the my lord rule.
Well, that is compliant, and because of we have served them, they only have.
We are suffering, but this is our duty to approach the court, my lord, and get the matter, my lord, heard.
Have you received copies of the plaint and petition?
That has been annexed with the.
Oh, annexed.
Application, my lord.
It's annexed
Yes,
with the state petition.
Already annexed it.
The day I received the application, that day only they go and say that we have not received the plaint and the injunction.
Be angry, don't be angry. Anger is not good for health. You know, always smile. Lekho, this appeal is directed against an ex parte ad interim order of injunction dated April 7, 2025, passed by the learned judge, commercial court at Rajarhat, North 24 Parganas, on a suit, in a suit filed by the respondent number 1 herein. Stop. Paragraph. The appellant says that there is an agreement with him for development of a property. Stop. He has developed the property, spending substantial sums of money. Stop. Because of the order of injunction, he is unable to transfer the flats
respective flat
in the property. Stop. Hence this appeal. Paragraph. We see that the order impugned was passed in the absence of the appellant. Stop. It was an ex parte order. Stop. Service of the plaint and petition has been effected on the appellant by the plaintiff. Stop. Nothing prevents the appellant from approaching the learned trial court with an appropriate application for vacating the order. You better do that, because that will be better. Let us not pass direction for affidavits. You do that.
We approach.
Yes.
But time limit may be there.
Stop. Paragraph. We therefore do not entertain this appeal. Stop. This will not, however, prevent the appellant from applying for vacating the order of injunction. Stop. If such an application is made within a week from date, comma, learned trial court is requested to dispose of the same as expeditiously as the business of the court may permit, and preferably within 2 months from the date of a copy of this order being placed before the learned trial court.
Rule mandate 1 month. 3A.
Huh?
3A provides within 1 month application will be disposed of. Code of
As
Civil
expeditiously
Procedure,
as possible, in accordance with law. That will cover that 1 month also,
Yes,
in
Rule
accordance with
3
law.
mandates.
Very well. Lot of mandates are there regarding time period in several statutes.
Yes, structure is.
How far are they adhered to, sir?
But we are suffering since, my lord, receive money from the purchaser, and my lord, we are not, my lord, ready to, my lord.
No, we
hand
understand.
over the
Go and apply tomorrow.
But they are protected by the order of this honorable court by depositing 10 lakhs. Money, he will not get the, my lord.
Tell the learned trial judge about all these things.
Yes, my lord. If he succeeds, then he will get the monetary, my lord, benefit, not the land, my lord, because land already utilized.
You are suffering. Your client is suffering.
Yeah, my client. I deeply oblige.
Disposed of appeal application.
Item 7.
And for the petitioner, my lord.
Respondent, Ms. Bose, have you served?
My lord, this is the first day, my lord.
Appeal against what? Learned trial court's order?
My lord. No caveat, my lord.
देखिए एक बार The matter was made determinable by the learned trial court on 22nd April.
My lord.
What happened on that date? Impugned order, Ms. Bose, is 11th of April, where ex parte ad interim order was not passed.
Not passed.
But the matter was directed to be listed after service on 22nd April. What happened on 22nd April?
Well, I'm told the requisites were filed on that day.
Yes, that's all. The other side, have you effected service on the other side in the trial court? Yeah.
But service was not effected.
My lord, the service was not effected. The requisite was filed. We had prayed for appointment of a receiver, my lord.
Yes, Ms. Bose, but you see the 11th, the order impugned, it says requisite are to be put in forthwith so as to ensure the service of notice
Requisites have been put.
upon the respondents.
On that very day, I'm told requisite had been filed.
We want to know whether service was effected. Find out. You better go back, Ms. Bose.
Can it be kept on Thursday, my lord, or tomorrow?
No, we are not inclined to interfere. You renew your prayer. It has not been finally rejected. The application has not been disposed of. Your injunction application is pending. Only thing what was declined was ex parte order. So now that service has been effected, go and renew your prayer. You may well get an order if you have a case on merit.
We have a good case on merit, my lord.
So given pleaded before the learned trial court in a contested application. Now that
The vacation approaching, my lord, there is an urgency to appoint a receiver. It is a brick field, and every day
your advocate on record is not even sure what is the present status, whether service was effected or not. Come back day after tomorrow with proper instructions. এখানে কি service করে দিতে হবে? ফেরত পাঠিয়ে দেবো, আসুন।
Item 9.
But coming up against an ex parte order of an injunction, by which my business has come to a halt for a certain reason, the order, if your lordship sees, overreaches the prayers of the petition itself. And secondly, on a very equitable ground, cease and desist notice was given in September 2024. Reply by us stating that I am a prior user with details of my applications in the reply to the cease and desist notice, October 2024. Mediation was initiated by the plaintiff. We participated. They did not give the documents as per the directions of the mediator. We did not participate. The mediation did not fructify. He moves an application ex parte and gets an order of an injunction overreaching the prayers which they have prayed for.
Serve, come back. 21st April, the order was passed.
I understand, Malad.
15th of May, you filed the appeal.
I bow down. I bow down.
Serve and come back. Come back day after tomorrow.
Very well.
This order is directed against Taiture. Directed against an ex parte.
Lordship.
This appeal is directed. তুমিও লিখে যাচ্ছ। This appeal is directed against an ex parte order of injunction dated April 21, 2025, passed by the learned commercial court at Asansol. Entitled suit, bracket commercial, bracket close, তারপর colon দাও, 4 of 2025. Being a suit filed by the present respondent. The paragraph, let service of this application be effected on. Oh, ex parte, why don't you go and apply?
The only thing I'll tell you, Lordship, I had to come up before your Lordship because on the face of the face of the order.
Maybe ex parte order has not been passed. I mean, it has been passed.
I have to pray for an order 39 rule 4.
Yes.
And there, my lord, written objection. My business has come to a standstill. That's why I was not going into the merits of the case. I was not going into the merits of the case.
Because it will only delay your proceedings if we ask you to serve.
Business has come to a standstill because of an order which overreaches the prayer.
Yes, so therefore it's so urgent that your client waited for about a month before presenting the appeal.
23rd, it was served.
What served?
The plaint and the petition.
Yes, 15th of May.
Only the petition.
15th of May, it was presented, your appeal. Go back and apply for vacating tomorrow.
Only for the thing, your lordship has that discretion, only to see the order and the prayer. And that an ex parte order after mediation has been initiated. Mediation can only be initiated if there is no urgency. And they come up and get an ex parte on the basis of an urgency. They could have moved it, taking dispensation on 12A, They could have taken a dispensation of 12A if there was urgency. If there was urgency, they could have sought dispensation. They did not.
Service report, show cause by the defendants. Oh. 5th of May, what happened?
Yes, 5th of May we went. What they did was there was a police complaint which came to the court and on us. that this injunction has been passed.
5th of May, you went with a vacating petition?
No. I went because it was served
Why not?
to enter my appearance on that day.
Mr. Basu.
But on 4th of May,
Mr. Basu, don't give us all that.
but we went there.
23rd May, the order was served on you.
Yes.
23rd April, I'm sorry.
Yes.
And you wait till 5th of May, do nothing, just go and show your face and say a police complaint is there. Your client's conduct does not show there's.
That was served on us on 4th of May. The police.
If you want, we'll reject it with comments, which we don't want to do.
There was only two things, my lord. The act of the conduct of the plaintiff. My lord, dispensation could have been sought, my lord, under
Don't you go and make this grievance before the learned court? We are not shutting you out from anything. All we are saying, you have not had the opportunity or you have not told the learned trial court about your grievances.
I fully appreciate it.
Yes,
Fully
go and apply tomorrow, or who stops you? We'll say that if you make an application, expedition, we can say that because your business has been stopped.
Yes.
We can say that.
An ex parte order, my lord, where mediation initiated, urgency has been not be required. He comes and takes it on the basis of an urgency. But in that event, my lord,
then give notice and come back.
But I would be praying only for one thing. My lord, your lordship can remand it back after hearing me, not on merits, not required on merits. On, my lord, mediation,
You
delay,
give notice, come back day after tomorrow.
I'll grant a stay and demands it back. Not a problem, my lord, for me. I don't require a setting aside also.
On the respondent, and affidavit of service we filed in court on the next date.
But
Paragraph.
there are three pages which were missed out in the stay application, which was there before the trial court. My lord,
Stop.
may I file my supplementary
Paragraph.
affidavit?
List the matter once again. Purshudine date thou. Stop. Paragraph. Supplementary affidavit filed in court today on behalf of the appellants be kept with the records.
Great. Non-commercial.
Two 66301. Non-commercial matter, affiliate site, item number 1.
Chalo.
Item 4.
May it pleases my lord, I'm led by Mr. Shakhu Sen. My lord, he's on his legs, my lord. May I pray for very short passover?
Yes.
So grateful, man.
Item 5.
But I appear on behalf of the respondent, my lord, this section 37 appeal, which I am opposing. Difficulty is, my lord, if lordship sees the last few days order, lordship might recall about a fortnight's back, I made a submission and they said there was a bereavement in the family with regard to the
Mr. Dev, you know our practice.
I know, my lord.
Second call, we'll dismiss it.
This has been going on. This is the only thing.
Second call, we'll dismiss it. But
Lordship has recorded.
somebody is coming.
Oh, yes.
Mr. Bordhan is coming.
Yes. Come. Notes of argument will not have been filed. It's a very short point, my lord. Though 37 appeal, hardly there is
Not a short point.
Very.
Not a short point.
Long point.
10 lakhs award, my lord, 34 rejected. Discussed everything. Now Lordship would ascertain the scope of 37. Whether reapplication of evidence is permissible or not. Law says no, my lord. We have filed our written notes, my lord, both of us.
No paper book was directed to be filed.
Yes, my lord, papers have been filed.
Have been filed. এগুলো কি দিচ্ছ? পেপার বুক হয়ে গেছে তো। Award is page 101.
101, my lord. My lord, 3 partnership agreements.
Allow us to read the award. That should explain
My lord.
the factual.
My lord.
নোটসটা এখন যদি লাগে আবার দেখাবো
Page 126 দেখাবো। Thank you.
করে দিচ্ছি মেমোটা কপি দিলে
তো কিছুতেই বুঝতে পেলাম না, কিছুই করে বুঝতে পারছি না।
Seen the award, Mullet?
Yes.
But kindly see page 103 for once. This award or the operative portion, Mullet, of the award at page 105 comes after the Mullet, the finding of the arbitrator at page 103, the third paragraph, Mullet. It starts with after the pleadings. Mullet, after the pleadings were filed, the evidence tendered and arguments made by both the parties, it appeared that the only disputes is the dispute relating to accounts of 3 partnership firms. Similar, there are 3 partnership firms, 3 separate partnership agreements, 3 separate arbitration clauses in 3 agreements. Despite repeated directions given by me, none of the parties could produce the books of accounts, bank statements, audited accounts of income tax returns. Then, Mullet, even after going through the pleadings and evidence on record, it was not possible for the arbitrator to arrive at a finding with regard to the entitlement of the claimant in each of the partnership firms. But after this finding, Mullet, the respondent has been called upon to pay 10 lakhs and odd. After this finding, the arbitrator himself was unable to arrive at a finding with regard to
Then
the
he
entitlement.
appointed a chartered accountant.
Mullet, may I come to this?
By
Mullet?
consent.
No,
Recorded.
fine.
Then consent was withdrawn by his
Yes,
time.
yes.
I will show from the minute. That's the point.
Mullet, we'll not travel that far, Mullet. We'll not travel that far. Mullet, kindly comes to page 104.
That's the only point.
The last page, the last paragraph, page 104.
Yes.
Now the arbitrator says the arbitrator's findings in respect of the dues of the claimant in each of the 3 findings is based on the evidence on record and report of the chartered accountant. Similar, the arbitrator says after going through the evidence record, he doesn't find anything. So the only, Mullet, the only document which he looks at is the report of the chartered accountant. Mullet, kindly takes page 174 for once.
This is the report.
Yes, Mullet. Mullet, see 2.1. So the other nuances will come to this, but kindly see paragraph 2.1. At the outset, we report that as per your requirement, we are not in a position to certify the net profits of the 3 firms. So the chartered accountant is also not able to quantify, Mullet, the profits of the 3 firms. So, Mullet, on what basis, if I'm posed the question to myself, Mullet, on what basis has the arbitrator come to these figures? The burden of proof lies on the claimant. Then, Mullet, kindly sees Shubhankar Apartments, Bhagavati, I'll be placing all, Mullet, and then Shamkunj. In Shubhankar, it says no records are available. In Bhagavati, There's no finding worth the name. And my lord, in Shamkunj, he says 175 at page 178.
Just what did the learned trial court say?
My lord, kindly see one more, my lord, page 103. Kindly sees, my lord, in a suit for accounts, or my lord, in a claim for accounts, what is the case of the claimant? Page 103, my lord. Last 5 lines. The claimant on whose behalf her husband Dipankar Dottoray appeared had all along submitted that she was not in possession of the complete books of accounts, and the same were in possession control respondent 1. So, my lord, there's nothing brought by the claimant. Nothing brought by the claimant, my lord. The arbitrator himself says, on the evidence and record, I've got nothing. I can't figure out what the actual quantity would be. Relies upon a report of a chartered accountant. The chartered accountant, my lord, in no uncertain terms says it is not possible for us to quantify and clarify the net profits. On this basis, my lord, this award was passed.
Yes, and then what did the learned trial court say?
205. 205.
205. এই আরেকটা আছে, হ্যাঁ এইটা।
So the decision starts from page 211. The points for determination and, my lord, the decision with reasons. Let's seize the points for determination, my lord. Impugned order dated such and such suffered from illegality, impropriety, irregularity. Whether the impugned award was passed in accordance with the provisions of the law, calls for an interference, impugned arbitral award is set aside. Then my decision, my lord. Now, my lord, 2 aspects, my lord. My lord, 217 4.16 and then 4.17 and then 4.18 at page 217. My lord, these are, my lord, after all the discussions, this is what, my lord, the learned judge in the court below had held, my lord.
You could also consider, my lord, sorry, my lord, he's arguing 212, where the report discussion with regard to the report has commenced.
I'll place the entire order.
First discussion, then the subsequent.
No, I'll help.
4.4.
No, may I place 4.16 minutes?
How will be appointed?
He was appointed. That he was appointed is beyond any.
Respondent was asked to produce, they did not do anything, they were in control, all recorded by the arbitrator as well as by the. And they never appeared. In spite of notes.
সব করে দিচ্ছে আমি পড়াচ্ছি না কোর্সপন্ড দিলাম না হ্যাঁ পারবো না
Yes.
My lord, kindly comes to 4.16 of the, my lord, the trial court order. My lord. The examination of the award passed by the learned arbitrator, as well as the report of the chartered accountant by this court, has been done with the limited purpose of arriving at a conclusion to satisfy as to the conditions of 34(2)(b) of the Arbitration Conciliation Act. The non-registration of the partnership deed as per the Partnership Act is no way puts an embargo. My lord, we are not on that. My lord. Then, my lord, the scope of interference has been explained in detail by the Honorable Supreme Court in the above referred to decisions, Associate Builders and Sanyong. Then reappraisal of evidence is not permissible only if it exists as a total perversity in the award. Now kindly sees the learned judge in the court below refers to only 34(2)(b) and my lord omits 34(2)(a) in its entirety. 34(2)(a), my lord, sets out an arbitral award arising section 34(2)(a) of the Act. My lord. No consideration worth the name of 34(2)(a). The arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the record. Now, this exercise was supposed to have been conducted. Now, the learned judge in the court below proceeds as if only, my lord, 34(2)(b) is in fray, as if 34(2)(a) is wholly absent, my lord. Then, my lord, kindly sees the report of the chartered accountant, paragraph 417. The report of the chartered accountant and the award passed by the learned arbitrator thereon reveal that the share of the OP number 1 stated to have been determined in respect of 3 projects, namely Shamkunj, Shubhankar, and Bhagavati. In view of this, when the proceeding before the learned arbitrator has been conducted after recording evidence of the parties and the material placed by the parties, in this case, the petitioner has not been able to demonstrate as to any incapacity on the or that the arbitration agreement is not valid. No, we are not on that. We are on total perversity, patent illegality, my lord.
Yes, Mr. Dev. From where does the learned arbitrator get these figures?
He gets this figure, my lord, from the report of the accountant.
How? Show us.
My lord, just, my lord. Before that, my lord, he has indicated one thing, my lord, that all the documents were not placed. And that's how, my lord, he tried to interpret or sought to argue that the chartered accountant did not have all the documents, did not have the
report says so.
Report says, but prior to that, some other observations have also been made that I would indicate which he did not place. The chartered accountant proceeded on the basis of the documents which were made available to him. He can't force a party to produce a document if the party who has it and does not produce it.
No, that is very well understood. But
Now,
then,
kindly
how
see.
can he file a meaningful, effective report if the parties don't produce all the documents?
He has proceeded, and the conduct of the party is very important. Whether that amounts to perversity or not, that lordship would not consider. That's the only point. Kindly, my lord, comes to that. I will place the page, my lord, the 3 minutes of the arbitrator, which is very important according to me. When you challenge and say it's perversity, and purely on the ground of perversity, the award needs to be set aside, and that has to be apparent on the face of it, because you are not now inviting the court to reappreciate the evidence, meaning thereby the report of the chartered accountant is being questioned now, is being questioned, whether that can be questioned or not. Kindly comes to me. Sorry, whether this can be questioned or not. That's the point. I will show you the figure. Kindly comes to page 283 once. All happened after hearing was concluded. The learned arbitrator felt that this is basically a claim for accounts, so he did not have the expertise, and he found it appropriate to appoint an expert who will find and go into the records, and a detailed report will be filed. And that is exactly what he had done on the basis of the reports or the documents produced. Page 283, Bullet. How he was appointed is very important, Bullet. Bullet, last 2 names lordship would find who appeared on behalf of the respondent number
page 283.
283, Bullet, I'm sorry. and they had the report.
Yes.
It was served. No challenge was made to the report, no exception. But kindly see, Mulot, they appeared. It's not that an ex parte appointment. After going through all the evidence filed in the reference, I feel it will be necessary to appoint a chartered accountant to scrutinize the accounts of the three partnership firms, so and so, so and so. The parties are directed to suggest the name of the accountant by Monday and inform the arbitrator. The chartered accountant will be at liberty to scrutinize the entire accounts and seek clarification from both the parties. Parties were also requested to cooperate, and the chartered accountant give the chartered accountant access in the books and accounts which are in their possession. That is very important. So whatever they had to produce. And my cases specifically, the respondent were in control. They were the controlling partners, and they just threw me out after the construction was completed. Now, Mulad, kindly see, Mulad, the chartered accountant should file a report. So it was passed in their presence. Next page, Mulad, 284. Then they take a different stand. A letter was written by Mr. So-and-so, the advocate appearing for the respondent, Mulad, now. So-and-so to send to the arbitrator. In the letter, Mr. Sen stated that the papers and documents related to the accounts of the firm and lying with Mr. So-and-so, who has also appeared in the reference and witness for the crime. Mr. Sen also says his client is not in a possession of the documents or the papers relating to the accounts of the firm except those which have been annexed to his counter statement. Mr. Sen so-and-so submitted. Then he goes on to state that all the documents called on in the record as and go would amount to fishing of evidence and the purports to lead to a fresh trial. Mr. Sen stated that his client is not willing to pay the share of the chartered accountant, and he also stated that it would not be possible for them to participate. After agreeing to this, then our submission was recorded. Mr. So-and-so appeared, and it was open to the client to object to the appointment of the chartered accountant last sitting held, but he did not object. Work assigned to the chartered accountant. If further submits in the interest of justice, this may be treated as an application on the part of the respondent. The claimant be given an opportunity to reply. Then, after considering this, the arbitrator fixed the next seating. Then the last one. Kindly see page 286. They stopped appearing. They did not appear. Page 286, the Lordship has got that. Nobody appears on behalf of the respondent upon consideration of the later dated written by so-and-so and after affidavit so-and-so. It is directed the chartered will be at liberty to examine all the documents which are on record in the proceedings. All the papers filed in the present proceeding excluding the minutes shall be filed before the chartered accountant by the claimant within a week from the date. The chartered accountant will be at liberty to seek clarification from both the parties. And they did not appear, never appeared, with regard to the accounts of partnership. And after receipt of all the papers, chartered accountant will indicate by the later date so-and-so will need file a report as directed. Then chartered will ignore the statements in the pleading so-and-so, but that has been recorded. Then 287. Nobody again appeared on behalf of the respondent. The report of the chartered accountant was served upon the advocates for the claimant and the respondent number one, who is being now Mr. Bodhon is appearing. Mr. So-and-so appeared for the claimant. Subway accepts the finding of the chartered accountant. He seeks leave to file the statement showing the dues of the client. The hearing stands concluded. So, in spite of receiving the notice, they never appeared. They never objected. Now, kindly see the finding. So, they had the opportunity. And the best way is to file an objection when you are aggrieved by the report. It's like a commissioner's report. Never, nothing had happened. Now, kindly comes to the finding of the chartered accountant. He had shown one particular paragraph. Let me show you the other averments. The findings of the chartered accountant. Page 174, Lordship would kindly comes to. This is the conduct very important. The Lordship will be rising. Sorry. It kindly comes to page 174, the report. Basically, his challenges to the report, and he says the finding of the report is incorrect, and the learned arbitrator has proceeded solely on the basis of the report. Therefore, proceeding on the basis of the report, which is incorrect on the face of it, finding is also incorrect. It has to be.
Mr. Dev, it's not only that. We do not see any independent application of mind. This is delegation of a power to decide delegated to a chartered accountant. Practically, this is the thing.
But,
No, Mr. Dev. Our conscience, as at present, advised. You make your submission anyway. You can't improve on what there is on record.
The facts, my lord, I
Yes.
have to argue. Page 174, Lordship would kindly comes to my lord.
Yes.
May I, my lord? In respect of the above matter, we were appointed chartered accountants to scrutinize the books of accounts of the three firms and so and so. In terms of the said letter, we were required to file a report indicating the net profits made by each of the partnership firms after they were constituted. In pursuance of the above letters, so and so, and issued by us to both the parties to the arbitration, asking them to produce before us several documents for the purpose of scrutiny. Whereas in response of our aforesaid letter, the claimant produced before us several documents and offered clarification to the points sought for by us through her representative. The respondents, that is Mr. Ashok Kumar Shaw, who is the appellant now, and the others wrote a letter, vide so and so, denying their consent to the appointment of the chartered accountants in this matter. In the context of the aforesaid development, in reply to our request to the clarification, we were advised by you that we shall be at liberty to seek clarification from both the parties with regard to the accountants of the partnership. In view of the letter already received by the advocate of the respondent number 1, VDS was denying all the cooperation to, we have examined the position on the basis of the information and explanation furnished to us by the claimant. So what would be the presumption, my lord? If I ask somebody to produce the document, and if you don't come and produce, then what will I do? So, my lord, what would be the presumption, my lord, lordship would, my lord, kindly consider? If I hold a particular document, which according to me is very important, and that needs to be produced before a particular authority or before a particular person for consideration, and if I hold it back, then what the court will do, or what that particular gentleman will do? Presumption of holding a document, adverse inference whether court will draw or not. That's a very important thing. And at what stage?
They are saying it was not with them. You are saying they are withholding. They are saying the documents were not with them. Whatever were available were filed.
Now they are saying. So how would you say, my lord? Just, my lord, let me, my lord, ascertain. Absolutely, my lord, I am grateful to your lordship. Today, my lord, if an appointment is made, and if you are asked to produce documents by an authority, and if you don't appear on the subsequent days, and when a notice was given to you to produce the document, if you don't turn up, then at this stage, in section 37, can you agitate and argue that nothing was there or I didn't get an opportunity to adduce it? So what the chartered accountant did, he had proceeded on the basis of whatever the documents were made available to him.
Very
It may
well,
not be
Mr. Dev,
appropriate.
very well. Show us how the report, which portion of the report supports the figures arrived at by the learned arbitrator.
My lord, what the learned, my lord,
Assuming this is a good report,
absolutely.
which portion of the report supports the award?
My lord, let us, my lord, come to, my lord, page 175.
Yes. Bhagwati, no, Shubhankar.
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 3 projects.
What was awarded by the learned arbitrator
Arbitrator awarded, my
in
lord,
connection with Shubhankar?
sum, my lord, principal sum 10 lakh 10,339.
That is the total. With regard to Shubhankar,
No. In connection with
Shubhankar.
Yes.
Shubhankar, he has awarded
1 lakh 3 lakh. 1 lakh 3,000.
And Bhagwati, he was awarded 1 lakh 50,000.
Now, this 1 lakh 3,000, how does he get from the chartered accountant's report? Just show us that.
But what the learned chartered accountant, what he did, he has recorded all the things and he has said, kindly place this, the exact figure, I can call my client to prepare a chart because he has detail, exact figure.
No, not necessarily. All we want to know, show us how the award is based on this report.
Absolutely.
How does which portion of the report prompted the learned arbitrator to say that in connection with Shubhankar, 1 lakh 3,000 is payable to the claimant?
Very well.
Just show that.
Very well.
On the contrary, this 1 lakh 3,000 figure, the claimant has recorded in her evidence. It is picked from there. It is the claimant's case that 1 lakh 3,000 is payable to her in connection with Shubhankar.
Yes.
Which portion of the report supports that?
May I place this?
You want to consider? Have you got our query?
Absolutely, Lordship.
3 partnership firms?
3 partnership firms.
3 amounts awarded by the arbitrator?
Absolutely.
Which portions of the report support these 3 amounts?
Absolutely, my lord, I got it, my lord. My lord, may I, my lord, for that, my lord, I have to, my lord, just, my lord, consider this, my lord. 1 day's accommodation, I can get it.
Come back tomorrow. Finish it off.
Absolutely, absolutely.
কালকে কিছু fix আছে করা?
I have some other points to canvas. If my learned friends is able to overcome this hurdle, I'll canvas those.
I heard Mr. Bordhun, learned counsel appearing for the appellant, concludes his opening submission. Paragraph. Mr. Deb, learned senior counsel appearing for the respondents. Respondent number 1. The others never participated.
They got it, my lord, they participated.
Respondent number 1 begins his argument but does not conclude. Paragraph, list the matter once again. Kalki date diye do.
Grateful. But tomorrow, my lord, doesn't take up this matter. So there would be a time frame. Thursday, Friday.
No, they'll be running in the list. You never know. The other lists may collapse suddenly.
Thursday, Friday, I'm some inconvenience. But tomorrow, I'm there.
No problem.
I'm so grateful.
I got, my lord's query.
I'm grateful.
You're right, Mr. Dev. We will not perhaps go into the sufficiency of the report, but at least just show how the report supports those figures.
I would, from the figures.
Otherwise, those will be arbitrary.
Absolutely, I got your point.
So that's where the learned judge in the court below failed, He did not examine that patent illegality. I'm so grateful.
Grateful.
Item 6.
My lord.
My lord, 6 I am for the appellant.
In this matter, I am for the respondent. I am extremely sorry, my lord. Till date, I have not received the wakalatnama of the legal heirs of Mr. Himanshu Bharadwaj, and they are not they are avoiding me, my lord. So kindly fix it. I will serve a letter upon them, and I will return.
That is not the appellant's problem. That you have not.
Well, the gentleman expired sometime in
He is a very
2018.
nice person, my lord. But his legal heirs, his daughter and his sons, they are not cooperating with
Only
me.
what happens when
They are not cooperating, then why are you so keen on representing them?
Well, I'll
If
tell
your clients are not cooperating with you, why do you want to
the
represent them?
gentleman expired sometime in 2018.
No, 2020.
5 years have gone.
Well, they are proceeding with the execution proceedings. Once we came to know about this, he has given us a copy of the death certificate. We filed an application for substitution.
What
We
is
got
this?
it
Is a section
substituted.
37 appeal?
Yes,
How much is the award amount?
15 lakhs. Well, we have deposited in 2020, 15 years ago.
So you are enjoying a stay? No.
No,
What no?
only while subjected, we have paid 15 lakhs at Punjab National Bank. It is with the registrar. Original side, it's there.
You have deposited the award amount, but there is no stay of a.
The execution proceeding is pending.
Are you sure?
Yes, yes.
Why would you deposit the amount otherwise?
That was an order passed there. List of- No, this is washing management.
কিছু জানে না।
In 2000,
Mr. Das, prepare yourself.
no, but it's okay.
Well,
But
We are not sure you are being properly instructed. Why would the appellant deposit the awarded amount unless the appellant is granted an order of stay? That must have been a.
Even if see order of stay is that he says that, but they are proceeding with the execution proceedings.
Who can this? Nobody seems to be knowing anything. Please find out and come back in the reopening week.
Yes, my lord.
This is an old appeal of 2008. 2008.
If he says.
Yes, if you without a wakalatama, how will you appear?
But he's appearing throughout. Substitution application is appearing. Change of
You will
name.
get into trouble, sir. Please consider. Don't do this.
I've told him also.
We are not concerned about your clients. We are concerned about you as a member of the profession. Without wakalatama, without authority, how are you appearing? Later, allegations will be made against you.
Well, but if he doesn't have the wakalatama, he has given us the copy of the death certificate.
So finally, tell us when this matter next appears in the list, whether you are appearing or you are not appearing or disappearing. Old appeal of 2008. Stop. On the request made by learned counsel for the parties, let this matter stand adjourned and be listed again on reopening day. You'll be here.
Yes.
June 9.
May 2009, we have deposited 15 lakhs.
Question is, why would you deposit unless you get some benefit out of depositing? That benefit must be the stay. Exactly. Automatic stay. Automatic stay.
Someone else was appearing, my lord. I'll take the
Please take instruction and come back.
From KMDA.
Come back. 2009, there was an automatic stay.
Yeah.
Filing of 34 would operate as a stay. So there was no requirement on your part to deposit also. Anyway, find out, come back.
Item 7.
Please, my lord.
Let's see, may I please? Let's see, I am for the appellant.
Yes, this is item number 7.
Let's see.
Yes.
Let's see, in this appeal that is filed under section 37 of the Arbitration and Conciliation Act, I have assailed the order of the impugn order, that is the judgment passed by learned ninth bench, Judge ninth bench, City Civil Court, in miscase number
What?
1547.
Yes, what? You want to say something? You ready in the matter? Very good.
Lordship,
Yes.
that is miscase number 1547 of 2016. My application under section 34.
Yes.
2B of subclause Roman 2. That was dismissed by the learned Judge City Civil Court. In that application, I have challenged the arbitration award.
Where is the impugned order? Page?
Lordship, before that, I am just briefing the very nutshell, the fact of the case.
Nutshell will appear from the impugned order. Tell us the
Lordship.
page.
Volume 2.
Volume 2.
If my lord may permit, may I just brief out for a moment?
Just.
Why doesn't the learned trial court record the facts of the case in the impugned order?
Lordship. Lordship, I am taking Lordship's kind attention to page 31A of that impugned arbitration award order. Volume 1. Para 7.1. Lordship.
Who were the respondents in the arbitration? SMC and another. Who is this another?
Another is the learned arbitrator.
Huh?
They have been made as a Manoj, award was in our favor. We filed.
Well, who were the parties? Apart from SMC, there was another party before the arbitrator.
No, my
Huh?
We are for the respondent, Lordship.
Okay. My lord, they are asking about
Original
Section 34 application shows an another. Who is that another?
Another one. Another is learned arbitrator.
In volume 1, annexes in volume 1, page number 23, it has only two parties in the arbitration award. SMC Global is the petitioner and the Jitendra Kumar Sahu is the respondent in the arbitration award.
And in 34, they have made learned arbitrator also as one of the party.
Oh.
Yeah, Lordship, I am taking Lordship's kind attention to page 26. Volume 1. That para 2 of that award, Lordship. In the statement of the case of the applicant, inter alia made the following submission. Mrs. Sam Global Security Limited merged with the applicant company Messrs. SMC Global Securities Limited by Delhi Court, order dated 26/2/2009, as a result of which all the assets and liabilities and business activities of the former company merged with those of the latter. The respondent is a
Sir, we
registered.
are trying to read the impugned order. You did not participate in the arbitration.
No, I have personally not participated, but I have submitted my state of defense. That is
Yes,
reflected.
tell us what do you want to argue?
Lordship, kindly come to page 27, Lordship. Paper book, volume 1, Lordship.
Yes.
Para 3.
Oh, permitted. Come back tomorrow. Mr. Mitra is here. Yes. There's a matter fixed at 12:30. Heard learned advocate for the appellant.
My lords, we have come from outside of Kolkata. I'm from Delhi and he's also from. If my lords may accommodate today after 2 p.m. or sometime in today.
No, but then
Counsels from outside.
we understand, but nobody told us that. You should have then told us that before coming, either virtually or your instructing advocate is here.
It's for specifically fixed for today's.
Nothing is specifically fixed, sir. It was in the list.
My only submission is if it cannot.
Sorry, sir. May not be possible. We'll keep it after the vacation then. Since you are both from, you are from where?
I am from the Odisha.
Odisha. We'll accommodate you. We'll fix a time for you also. Dakho vacation er por. Madam, you should have told us that your counsel is coming from some other city. Same here. Then we would have fixed it. We accommodate outstation counsel always.
Can I make a small submission in this matter? This is very small and it can be actually only 1 minute time I'll take.
But then we have not yet heard him.
There is a question of law involved. The award is 4 years belated. It was 34 was filed after a period of 4 years. The limitation period was condoned. Subsequently, 34 court had already decided everything upon the merit. The grounds they are raising is purely a factual thing. Even the constitutional recent judgment of the Supreme Court.
Sir, but we have to hold that this appeal has no merit. After hearing him, we have to hold that at least. Will you come back on the 9th, 10th, 11th? Say.
In the month of June, Lordship. Yes.
Where are you from? Delhi?
My lords.
Lordship, I am available. Lordship.
Can it be tomorrow, my lords?
No.
This side of vacation, we can't fix it for you.
First day is after 12.
For the appellant stuff, he does not conclude.
After 12. After 12. Any date after 12.
I have no preference.
As agreed by and between learned counsel for the parties, list this matter once again on June 18. Is that okay? Check up your diary.
Lordship.
June 18 marked 12:30 p.m. Marked 12:30 p.m.
Grateful.
Lordship, it may be kept pattern, Lordship. It may be kept
No, sir.
pattern.
No, sir. No.
Okay.
What is your good name, sir?
Alok Kumar Das. Lordship.
Mr. Das. And you are?
Yes, Jain.
কি হলো ডাকো 5 মিনিট তো এরূপ এতে নষ্ট হবে।
Not more fair. This matter act, item number 18/2/22.
বলো না
18/22.
Is your one also suo motu transfer?
এটা কি অ্যাপেলের সাইড? এটা যেসব
कल वाला भी ये वाला भी ये वाला हम करके दबा रहे हैं तो टाइम कल क्या करना कल सुप्रति को भी हम नहीं कर पाए
this is the JSOP matter.
This is with your lordship, before they begin, my matter, it's my lord a winding up matter where there's a suo motu transfer to the NCLT. My lord had said, my lord, because it's a winding up matter, my lord would consider it along with JSOP. It was to be listed. It's my lord come in the middle of JSOP. It's item number 19. We have, my lord, the facts are entirely different. I've ascertained, my lord, there is no link with our matter, my lord.
যেটা বলছি ডিট্যাগ করে দাও,
19. Cassian.
ডিট্যাগ করে দাও।
19 টা থাকবে ঠিক আছে
এটা কস্ট টাইটেলটা কি, যেটা আমার শর্ট নোট দিয়েছে এটা কি?
Yes, Mr. Mitra.
Make please, your lordship. My lord, I will not, my lord, I will try and avoid duplication of submissions. I think Mr. Bachat has made submissions on another matter. I do not know the cause title of that. A copy of the note has been handed up.
Mr. Bachawat, in this matter, JSOP?
Not JSOP. I do not know which is similar matter, my lord.
There were two other matters earlier in which I had obtained orders. Sorry.
From this bench? No.
Another division bench.
So we don't know what he submitted.
Yes, very well. Then I had no idea because no cause title was given. এটা কোথায় এটা?
This is the first title of that.
আচ্ছা, এটা কার ঘরে হয়েছিল?
We are covered otherwise. I am there in a different matter, not item number 19 over here. But issue is similar.
Yes, 19-year juniors are entirely different facts, so detag it.
So facts, I'll just indicate. But the question here is whether the company court can suo motu transfer proceedings.
Yeah, this is what Mr. Mitra is arguing now.
That's the same point, is it?
Yes. That's the point he's arguing now. So let him complete and then you can...
It's covered by it. If your lordship sees that two judgments which we have annexed to our application, it may be helpful to your lordship.
Covered by the Supreme Court?
Division bench. But I'll give it to my lord.
So why don't you place those? If those are on point,
yes,
we'll have to follow.
Really, my lord, this particular note had been handed over to me yesterday.
I see.
So I did not know of this until...
You were sitting on the table and he was discussing it. I didn't know that these were together.
Very kind
I
of
said
him,
in
he
my
walked
matter
up.
earlier, this is the note I had prepared. It may be helpful to you. But
So, my lord,
you argue in your own way, Mr. Mitra. You argue in your own way.
I argue now, and then in the meantime, let me check up your note also.
Katie, I'll give you a copy of my petition. Those orders are annexed. Keep it, but don't lose it. Give it back to me. Go annex. Thank you. অন্য ব্যাটারটা মার্শাল হাউসটা হাইজ্যাক করলেন, ওটা 12:30 ছিল।
ওটাও তো 12:30 ছিল। ওটা কি করবে বলে দাও জজ সাহেবকে। But there is another 12:30 matter in your lordship's list.
No, it hasn't come marked as 12:30.
Oh, I see.
It was supposed to. Marshall House was
That
supposed
Marshall
to
House, your lordship was pleased to
12:30.
grant liberty to look into the records, and my lord.
Not 12:30.
No,
No,
not
it's
marked.
not been. Your lordship had indicated 12:30.
তো তোমরা দেখেছো? Have you seen?
We've seen it, but there are 400 pages. We haven't been able to make notes. Let the matter be called on whenever.
মনে পড়ছে না। দেখো তো first matter 331.
এই নোটিফিকেশনটা আছে তো? এই 2016 নোটিফিকেশন। I will request your lordship to my lord to keep my lord two books, my lord, Companies Act 2013 and my lord IBC. My lord, these two should be before your lordship.
Companies Act.
Because I am going to refer to these and I am going to, my lord, look into the provisions of these acts.
Insolvency Banking Code.
পরে আসছি।
IBC ছিল এখানে। Yes, we have got it.
My lord, kindly come to section 434 of the Companies Act first. Section 434, we are really concerned with subsection C. 1C. Well, subsection 1 says, 434 says transfer of certain pending proceedings. And subsection 1 says, on such date as may be notified by the central government in this behalf. Then C, all proceedings under the Companies Act 1956, including proceedings relating to arbitration, compromise, arrangements, and reconstruction, and winding up of companies pending immediately before such date, before any district court or high court shall stand transferred to the tribunal, and the tribunal may proceed to deal with such proceeding from the stage before their transfer. Now, my lord, this particular subsection, there are so many provisos, and each of these proviso is important. Lord, kindly come to the first proviso. Provided that only such proceedings relating to the winding up of the companies shall be transferred to the tribunal that are at a stage as may be prescribed by the central government. So, my lord, it is not that all proceedings are being transferred. Proviso says that only such proceedings will be transferred to the tribunal which are at a stage as may be prescribed.
Has anything been prescribed?
Yes. This is what I wanted to show to your lordship. My lord, kindly take, my lord, a notification of the central government dated 7 December 2016. দুটো কপি দাও। দুটো, হ্যাঁ ওইটাই। হ্যাঁ, well, this is 7 December 2016. This is important. Lordship will please to come to this. First is in exercise of the powers conferred under subsection 1 and 2 of section 434 of the Companies Act, read with subsection 1 of section 239 of the Insolvency and Bankruptcy Code, hereinafter referred to as said code, the central government hereby makes the following rules, namely, then, my lord, kindly come to Rule 5. Transfer of pending proceedings of winding up on the ground of inability to pay debt. All petitions relating to the winding up under clause Z of section 433 of the Act on the ground of inability to pay its debts pending before a high court, and where the petition has not been served on the respondent as required under Rule 26 of the Company Code Rules 1959, shall be transferred to the bench of the tribunal established under subsection 4 of section 419 of the Act, exercising territorial jurisdiction, and such petitions shall be treated as applications under section 7, 8, or 9 of the code, as the case may be, and dealt with in accordance with part 2 of the code. Provided the petitioner shall submit all information other than the information forming part of the records transferred in accordance with Rule 7 required for admission of the petition under section 7, 8, or 9 of the code, as the case may be, including details of the proposed insolvency professional, to the tribunal within 60 days from the date of notification, failing which the petition shall abate. Then 2, all cases where opinion has been forwarded by board member, I'm not really troubling your lordship, this is not important. Then transfer of section 6, or rather Rule 6, transfer of pending proceedings of winding up matters on grounds other than inability to pay debts. All petitions filed under clause A and B of section 433 of the Companies Act 1956, pending before a high court, and where the petition has not been served on the respondent as required under Rule 26 of the Company Court rules shall be transferred to the bench of. Well, two things I wanted to emphasize on this. Kindly see, my lord, the proviso is that at a stage as may be prescribed by the central government. Now, the central government is saying in subsection 5 with regard to winding up under clause E of section 433 on the ground of inability to pay debt, that such proceedings must be, shall be transferred, which, my lord, on the ground pending before the High Court where the petition has not been served. My lord, kindly note the word, where the petition has not been served on the respondent as required under Rule 26 of the Company Court Rules 1959. Therefore, my submission is this, that perhaps the legislature wanted the central government to decide as to the stage at which, my lord, it shall stand transferred. And the central government decided that only where the petition has not been served on the respondent as required under Rule 26 of the Company Court rules, in respect of matters where the ground is for winding up is the ground of inability to pay its debts, there, my lord, this at the initial stage, before this, my lord, the service of the petition. This is, my lord, one. Then, my lord, kindly come back to the section again, 434.
The same thing, but it is not been acting up.
It's a key my lord, there another notification has been issued that is on the 29th of June 2017 by, again, my lord, the Government of India, Ministry of Corporate Affairs. I am not troubling your lordship with, my lord, the Rule 2 of this, because that is concerning the proceedings relating to voluntary winding up. Kindly, my lord, come to Rule 3. In the principal rules for Rule 5, which I have placed just now before your lordship, the following rule shall be substituted and shall be deemed to have been substituted with effect from 16th day of June 2017. So, my lord, this Rule 5, which I have placed before your lordship, has stood, my lord, substituted by Rule 5 of the 2017 rules. Transfer of pending proceedings of winding up on the ground of inability to pay debt. All petitions relating to winding up of a company under Clause E of Section 433 of the Act on the ground of inability to pay its debt pending before a High Court, and where the petition has not been served on the respondent under Rule 26 of the Company Court rule, shall be transferred to the bench of the tribunal established under subsection 4 of Section 419 of the Companies Act 2013, exercising territorial jurisdiction to be dealt with. Well, Lord, kindly in this connection, I look into Rule 400, Section 419 in your Lordship Companies Court Act. The Companies Act, my lord, Section 419, which has been referred to. This is, my lord, with regard to the benches of the tribunal. Section 419.
May not be relevant because
It is
transfer
not
is
yes.
So where transfer?
But it is not relevant. No, only because, my lord, the 419 has been referred, I thought that perhaps your lordship can have a look at it. So this is what it is. So therefore, again, my lord, my submission remains that where the petition has not been served on the respondent under Rule 26 of the Company Court rule shall be transferred. Then, my lord, kindly come to the next proviso. Kindly come to the next. Provided further that only such proceedings relating to cases other than winding up for which orders for allowing or otherwise of the proceedings are not reserved by the High Court shall be transferred to the tribunal. This is also important. Kindly remember the application. This is a second proviso to Section 434.
Yes.
Provided further that only such proceedings relating to cases other than winding up for which orders for allowing or otherwise of the proceedings are not reserved by the High Court shall be transferred to the tribunal. My lord, I have got twofold submissions to make. Now, either, my lord, what your lordship can look into this particular proceeding which is before your lordship as a proceedings in winding up. In fact, my lord, this is a proceedings in winding up. My lord, in a proceeding under, my lord, winding up under section 433E, this particular proceedings have been continuing. And in pursuance of my application in the winding up, I have been, my lord, directed to pay various amounts which I have paid, to which, my lord, I shall come. So, my lord, either that or your lordship can think that this is not a proceedings in winding up because it is an application under section 466 of the Companies Act. Of course, section 466 is, my lord, in pursuance of a company in winding up. So, my lord, it is really, my lord, a proceedings in winding up. So, first proviso will apply. But even if the second proviso apply, then, my lord, otherwise of the proceedings are not reserved by the High Court shall be transferred to the tribunal, not reserved by the High Court. My lord, my submission will be that where the proceedings have proceeded before the High Court and the High Court had passed order giving liberty to the party concerned to pay off the petitioning creditors, in pursuance of which orders, my lord, the petitioning creditors have been paid off, then, my lord, it is a proceeding in winding up. So, my lord, the first proviso will come into operation in my respectful submission. Even if second proviso comes into operation, I submit to your lordship, the court has reserved this because of the orders which have been passed from time to time. My lord, kindly note one very significant thing. These proceedings which have been referred to here are absolutely at the initial stage. It is not saying anything as to what happens after the petition has been served. It is saying that only those shall be transferred at a stage, and that stage is, my lord, where the petition has not been served. So I am putting these two together. Then, my lord, come to the next proviso. Each of the proviso, my lord, is important to understand the meaning of the main provision of 434C. Provided also that all proceedings under Companies Act 1956, other than the cases relating to winding up of companies that are reserved for orders for allowing or otherwise such proceedings. This is, my lord, one. Then next one, II. The proceedings relating to winding up of the companies which have not been transferred from the High Court shall be dealt with in accordance with the provision of the Companies Act 1956 and the Companies Act, Company Court Rules 1959. What does it mean? Well, I'm asking this question to myself. If it is a proceeding relating to the winding up of companies which have not been transferred, these proceedings have not yet been transferred. My lord, of course, I have preferred an appeal from the order which has been passed by the learned trial judge. Has not been transferred, then, my lord, it shall be dealt with in accordance with the provisions of the Companies Act. My lord, my respectful submission is this, that when the learned trial judge had entertained the application, my lord, this particular proviso should have drawn his lordship's attention to. And, my lord, the argument would have been that the proceedings relating to winding up of companies which has not been transferred, and that was not transferred at the time, shall be dealt with in accordance with the provisions of the Companies Act 1910 Company. And my very respectful submission is this section and the provisos make it very clear that at what stage it should be transferred. I will have to deal with, my lord, the Supreme Court decision. What is the meaning of irreversible position? My submission is this, that when, my lord, the High Court has taken season over the matter, considered past order, in pursuance of which orders actions have been taken, the parties have changed their position, then, my lord, an irreversible situation has arisen, which should entitle the court not to transfer it before the NCLT. Here, my lord, I just want to, in passing, I want to mention, I shall make my submissions afterwards. If it is transferred, there is no corresponding provision as 466. What is going to happen to all these payments which have been made? What is going to happen to these petitioning creditors who have come before the court? Their claims have been satisfied. what is going to happen to the workers' dues? If it is 1 crore, 72 lakhs has been paid. Now, my lord, if that has been done, these have been done, I say let us apply, my lord, the principle of the Supreme Court. An irreversible situation has arisen, which will entitle the court to exercise discretion not to transfer it before that. I do not know, my lord, what will happen, my lord, when it goes there. 466 application is not there. What happens to my application? In pursuance of which, my lord, orders have been passed, implementation of the orders have taken place.
They're giving you symbolic. The entire object of the act is to reconstruct the company, revive the company.
And symbolic possession has been given of the property. The official liquidator has been directed that you be in possession, but my lord, it will be in my possession also. And my lord, the security guards have been, my lord, have been installed there, who have been paid, my lord, from time to time. So what is going to happen to all this, my lord? I fail to understand and appreciate. So, my lord, I will submit to your lordship that if your lordship looks into these provisos, read them all together, then perhaps the inescapable conclusion will be that the stage at which, my lord, the courts have been given discretion to transfer, that stage I have crossed. That stage is no longer there. Then, my lord, come to the next proviso, fourth proviso. Fourth proviso is regarding the voluntary winding up. Provided also that proceedings relating to cases of voluntary winding up of a company where notice of the resolution by advertisement has been given under subsection 1 of section 485 of the Companies Act 1956, but the company has not been dissolved before the 1st April 2017, shall continue to be dealt with in accordance with the provisions of the Companies Act 1956 and the Companies Act Court Rules 1959. So, my lord, we find there is another, the proviso, which has, my lord, if I may use the expression, encroach onto the main provision. Exception has been carved out, by reason of which, in case of a voluntary winding up, the Company Court under 1956 Act and the Company Court Rules of 1959, under those rules, my lord, they will be continued to be dealt with under that. So, my lord, it is not that the moment you make an application, you feel that no irreversible situation has arisen. What is the meaning of irreversible? I could not understand. What is irreversible situation?
Possibly, where winding up liquidation is inevitable. It has reached a stage from where the company can't be saved.
So, my lord, if in a winding up proceedings, a person who is, my lord, formulating a scheme comes before the court and says, I am agreeable to pay off the entire the amounts in liquidation, the amounts which have been claimed by the creditors from time to time, and I want to revive the company, then, my lord, that will not be looked into. Whereas, my lord, IBC code, the primary purpose of IBC code is to revive the company.
For example, if all properties and assets have been sold off in the process of liquidation,
yes,
it will be impractical. Nothing is left.
I can understand.
That would be irreversible.
No, that will be irreversible. But does the provision of this act contemplates that kind of a situation? Then, my lord, if had it been so, then, my lord, the rules would not have been framed in this way. The rules are this: the petition has not been served on the respondent under Rule 26 of the Company Court Rules. Then, my lord, it says, shall be transferred to the bench. What is the meaning of that? I ask this question to myself. I am submitting to your lordship that the legislature had really indicated its intention. It was not the intention of the legislature that a company in respect of which a winding up proceeding has been, my lord, initiated, lock, stock and barrel, it will go before the NCLT. Because once it goes before the NCLT, section 7, 9, 14, all these will come into operation. What will happen is this: my lord, SCOC, that is, my lord, committee of creditors will be constituted, where, my lord, the primary, my lord, principal claim will be entertained of the financial creditors. Then, my lord, the workers and the operational creditors will not get anything. If, my lord, in the meantime, operational creditors who had been before the court had been paid off their dues, then what happens? Well, the IBC code, when it operates, it causes a lot of problem, if I may say so with the greatest of respect. My own experience had been this, that I'm just digressing for a moment. My own experience had been this, that a company which had undertaken, for example, I'm just giving an example, a huge work, for example, construction of road, construction of township. There, the company which has been in connection with the company in winding up, or the company which has gone for insolvency proceedings, had carried out a substantial quantity of work, incurred huge amount of expenses, have not been paid their dues. In the meantime, IBC court comes into operation. COC is appointed, Committee of Creditors. Proceedings, my lord, before the Committee of Creditors take place, financial creditors come into the picture. Ultimately, after, my lord, distribution of the money, the amount which is left for the operational creditor is a pittance. In order to save one company from winding up, you're winding up other companies, those who are operational creditors. This has happened. By protecting one company, by trying to save one company, you are putting another company into liquidation. Why? Because preference is given to the financial creditors, the banks, financial institutions, etc. Well, I submit to your lordship that it cannot be the intention. I say so, my lord, with the greatest of emphasis, cannot be the intention of, my lord, the legislators, that by constituting a new forum of IBC, seeking to revive the company, you put other companies into liquidation. And particularly when a company in liquidation is sought to be protected, sought to be revived by way of a scheme under Section 466, when there is no corresponding section in, my lord, the New Companies Act, what will happen to the section when the entire thing is transferred? How will it be decided? I am just asking this question to myself. Section 466, if it goes before the company law tribunal, how will it be decided? So, my lord, I submit to your lordship. Now, in the light of this, kindly come to the last proviso. This is the proviso which has come, my lord, by way of amendment in 2018. Provided further that any party or parties to any proceeding relating to the winding up of the companies pending before any court immediately before the commencement of the Insolvency and Bankruptcy Code Amendment Ordinance 2018 may file an application for transfer of such proceeding, and the court may, by order, transfer such proceeding to the tribunal, and the proceeding so transferred shall be dealt with by the tribunal as an application for the initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy Code. My lord, my submission is this: when your lordship looks into the entirety of the proviso, this particular proviso, I read it this way, that the transfer of the proceedings before the, my lord, the tribunal will be for the purpose of initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy Code. It is not for the purpose of revival of the company under Section 466. This concept of framing a scheme by my lord, a contributory or a creditor, that particular concept, my lord, will not be, my lord, within the four corners of this particular proviso. This proviso, my lord, is shall be dealt with by the tribunal as an application for initiation of corporation insolvency resolution process. But I feel that perhaps what is being contemplated in this proviso is that if it is a winding up proceeding which is before the tribunal, then winding up proceedings will be proceeded in terms of section 7, section 9, section 14, etc. But if it is not in that sense a winding up, it's a winding up proceedings, no doubt, but it's a revival scheme which has been made. Why not try it out by this court? Why should this court abdicate its power in favor of the NCLT? Where, my lord, the insolvency resolution process will start. God alone knows ultimately where it will go to.
When will you come back? এই দুটোর সময় continue হতে পারে? Do you wish to continue after recess?
Your lordship has got a bench, I think.
5 minutes, 7 minutes, maybe.
If your lordship wants, this is said, what me acho.
Suit yourself. We know this is 2 days away from the vacation, so.
Well, my learned juniors are much busier than I am. Therefore, my lord, kindly give me some other day.
একটা বেঞ্চ আছে দুটোর সময়। ও ওটা কালকে
কোনটা? Well,
tomorrow we have no other bench, you know.
At 2 o'clock. Then, my lord, your lordship will be pleased to go back to the original site commercial.
If you wish, we will continue with this, or will now the কি হবে? We'll go back to appellate side and exhaust the list.
Appellate side কি রয়েছে আর কিছু? আচ্ছা। Otherwise, my lord, I shall keep your lordship busy with my matter in the original site.
Very well. So let us just.
I shall be here.
So this will be adjourned then till after the vacation.
কি করবে? Till after the vacation. In the meantime, I shall look into my lord, Mr.
Bachawat's note. Yes, if we are covered at this point,
yes,
then it makes things much easier unless we.
I have to be very frank.
Decide to
I
differ.
have not considered Mr. Bachawat.
Mr. Mitro, দেখো অর্ডারটা করো।
কি হয়ে গেল?
Mr. Mitro, learned senior advocate. এটা দেখে নিও কিভাবে হচ্ছে, কম্বাইন্ড হচ্ছে না একটা ম্যাটারে হচ্ছে, দেখে নিও সেটা। Resumes his argument but does not conclude. When should we keep it?
Well, wherever is convenient to your lord.
Reopening week.
Reopening.
You will not be Mr. Surajit Nath Mitra will not be here.
Yeah, my lord. Only thing is, my lord, a prayer I made in the morning, my lord, I have to repeat it here.
Oh, do not repeat it.
No, but kindly don't keep it on the reopening. Kindly don't keep it on the first week.
Not the first week.
I shall be back on the 13th.
Very well. Very well. June 17th? 17 June? এটা রাখো, এটা রাখো। কে রাখবে? হ্যাঁ? 17 June. 17 June তাহলে তুমি এ করে দাও। 12:30 mark করে দাও।
And my lord, I shall prepare a note, short note.
Yes, better.
Yes.
Mark 12:30.
And my lord, can it be by consent?
Mr. Mitro, kindly don't do this.
My lord, this agency, my lord, I heard Mr. Mitchell submitting that they have been paid.
Substantial. Not even substantial. তাহলে তো আরো ভালো। You must get it from the company court.
Since this bench has heard this matter substantially, on the request made by learned advocates for the parties, let this matter be treated as heard in part.
I'm very grateful.
But make no further request in other matters.
But this series of matters. This
series of matters, so সবকটাই। তাহলে এটা কি একসঙ্গে হচ্ছে না? হ্যাঁ, তাহলে these matters.
Item number 18 কে এই ম্যাটারই?
Question has been tagged, your lordship, that is a separate matter. The same issue is involved, your lordship, but in item number 18, two matters clubbed together.
Detag it. If you want it to be detag it.
Same, it should appear as two separate matters. That's all that.
Please explain to us. বুঝে নাও কি বলছেন?
Otherwise, it's only one matter.
Please explain to our court officer. He'll do the needful. বড় 10 নম্বরটা কি ছিল ছিল না কেউ?
10 number question.
11
Lordship, I am appearing on behalf of the appellant. Lordship, I am being led by Mr. Ray, but in this matter, your Lordship had asked us to start, irrespective of Mr. My learned senior, Mr. Ray's.
Your other side is not here.
Other side is not there.
Yes.
Lordship,
Your other side was raising a grievance. That is why we said
if my other side is not there, Lordship can,
after vacation.
after vacation will be much better.
Nobody appears for the respondent. Stop. Appellant return in you, appearance. Paragraph on the request made on behalf of the appellant, comma, let this matter stand adjourned and be listed immediately after the summer vacation. Reopening day? No.
Not real.
On June 10.
Passover matter, item number 1.
May it pleases my lord, I appeal for the appellant.
Why to be mentioned?
Item number? Oh, sorry.
1. Oh, assign matter. কেন মানে দেখি কি ব্যাপারটা Cause title correction এর জন্য না কি কারেকশনটা চাইছে তাও তো যাই কি কারেকশন চাইছে তাও তো যাই না ইয়ে করে দে থাক নট টুডে করে রেখে দাও কি কারেকশনটা জানতে পারলে তো আমরাই করে দিতাম এটাও তো যাই না ফর অল ইউ নো দেখবি হয়তো কোনো কাউন্সিলের নাম দেওয়া হয়নি এইসব ভাবে কোন রাস্তা এটা তো তোরা তো ডিসপোজ অফ করে দিয়েছিস মনে হচ্ছে ও করবি কি আইসো এইটুকুই হ্যাঁ এই তাহলে লিখে নাও let the cause title let the name of the respondent number 1 in the cause title of the judgment and order dated March 19, 2025 be corrected as State of West Bengal, within inverted comma, in the place and state of State Bank of India. State Bank of India within the court. So let this correction be incorporated in the judgment and order such and such. ঠিক আছে? Correct.
আচ্ছা 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 item number 4.
And this is arising out of a rejection of my application under Section 8 of the Arbitration Act. But, if your lordship straightaway comes to the plaint.
But before my learned friend starts, my lord, I appear for the response number 1 and 2. But in my response submission, my lord, this.
You are for the Zilla Parishad?
Yes, my lord.
In my response submission, my lord, this appeal will not requires admission under order 14 rule.
You appeal under Section 37.
Kindly consider, my lord, applicable rules under Chapter 5, Rule 17A and 17.
I think there was a judgment, my lord, appeal under 37 was.
Let us say A. There is a division bench judgment of to that effect.
Statutory appeal.
Special bench judgment and division bench judgment.
Section 37 appeal requires admission.
It's statutory appeal.
Not 37, my lord. It is, my lord, kindly text, my lord, this is an appeal arising out of an order, my lord, passed under Section 8. Whereby, my lord, Section 8 application was rejected.
Yes.
My lord, this is an appealable order. No doubt under Section 37. But it requires admission, my lord, in view of, my lord.
No, Section 8 appeal is a 37 appeal.
Yes.
From an order rejecting Section 8.
Kindly text, my lord, appellate rules once. There is a judgment of division bench of our.
Then why rules? Show us the judgment then.
The statutory appeal.
This is, my lord, Anup Kumar Vishwas versus Babul Kumar Vishwas, 2003 4 CHN 275.
Copy है क्या? At that time, Section 8 order was not appealable under my lord Arbitration Act. আস্তে আস্তে হেলে দুলে আসে।
You want to consider and come back, Mr. Sen?
I just, then in that case, I'm just giving the citation of other judgments. Let him consider.
Okay, give him all the judgments.
Yes. But, first one, this is the first one. Second one is
2000,
2003, volume 4. 2003, volume 4 CHN 275. And then 2003, volume 3 CHN 326. And chapter 5, rule 17 of the Adversary Rules.
Give us all the other copies of the other judgments. We will also consider. এই ফাইলটা দিয়ে দিতে বলো তো বাড়িতে
The extract of the Adversary Rules is also there.
Mr. Sen, how urgent is this? You want to do it this side of the vacation?
Other point is eviction.
Well, only well, this is only for a clarification. In the sense, my lord, the trial court has recorded my learned friend's client to be a permissive occupier, and dismissing my Section 8 and injunction has been granted not to dispossess him otherwise than by due process of law. I am protected to that extent because I can take recourse to a due process of law and initiate a process. But, my lord, as a government, I can invoke a provision of a special act, public premises Eviction, a state act.
Unauthorized.
Yes, but but that if that observation stands, then I will be precluded from taking recourse to the
Why? That is due course of law, due process of law.
But here, even if it is a prima facie observation, it holds that he is a permissive occupier.
They're not unauthorized.
Not unauthorized. So my appeal will be actually restricted. Section 8 is substantive.
The other thing is, two applications were disposed of by a common.
Yes, I have filed a separate appeal.
You have to file another appeal.
Yes, I have. That's a separate. That is before the other bench, because that will require admission under Order 41.
We've understood. If you want us to keep this on Thursday, we will. No, we have no problem. So long as you.
But kindly keep it on Thursday, because I'll tell you, Lordship.
Mr. Tiwari says after vacation. They have some urgency, Mr. Tiwari. They are government.
It's a hospital, my lord. I have given them the premises for running a medical diagnostic and hospital.
21st March.
They are not, my lord, following the act. They do not even have license.
On 9th itself, my lord.
I have not dispossessed them also. I have initiated an e-auction for selecting someone else in their place, because they do not possess definite licenses.
Are they paying your fees, license fees or whatever it is?
No. That is anyway they are in breach. That is why I have terminated that agreement also.
Paid, Lord. They have requested me not to pay. This is their letter.
Yes, because I have already terminated.
That we are.
Even after termination, they have accepted the rent. Even after
and I have given
by mistake, they want to return it.
Yeah, I want to return it. I have asked them
so.
for their bank account.
They say so,
but they don't want to take it back.
Thursday, Milord, I have some person. Actually, Milord, whatever in my one Andaman matter, Milord, is fixed.
Andaman matter is fixed.
Fixed before the appeal bench, the principal bench. And the high stake matter, Milord, 72,000 crores investment is under challenge. So, Milord,
tomorrow?
Yes, I shall get ready and come back, Milord.
Keep it after vacation.
Persuade him.
Keep it on 9th. I will be coming on 9th. No issue. 21st March.
Then Friday, he says Thursday.
Last day, Milord.
So, it's a holiday.
More or less heavy holiday.
What have you?
I can come tomorrow, Milord.
Milord, keep it on 9th. I will be coming on 9th. Milord, 21st March order. Milord, now he is so urgent.
Talk to your learned friend. Why are you discussing with us? Still us.
Let us come tomorrow. Tomorrow, Milord, let us come back tomorrow.
Milord, keep it on 9th.
Come back on the 9th then. আমাদের ফাইলটা দিয়ে দিও এগুলো শুদ্ধ আমরাও পড়ে আসি একটু বাকি জাজমেন্ট গুলো দিয়েছো তো
9th is a Monday, my lord. 9th is a Monday, so I think appellate side is on Tuesday. So
no, there's no such thing. It's alternate. What will be Friday? Last Friday, if it's appellate side.
It is very difficult.
But it's very difficult to keep track, my lord. Kindly
very well 10th.
No, not for this matter. Generally, your lordship kindly give an instruction in the list on this date.
কেন দাওনি alternate days তো বলে দিয়েছিলাম।
But very difficult.
Thorough interpretation is required regarding instruction. Sometimes you have to consult a statutory interpretation.
কারণ একদিন ছুটি পড়ে গেলে এটা একটু হয়ে যাচ্ছে বলে। If today is appellate side, tomorrow will be original side. Day after tomorrow will be appellate side.
I understand.
Day after that. And if today is appellate side, day 1, appellate side commercial first, non-commercial second. Next appellate side day, non-commercial first, commercial second.
Lot of calculation, my lord. Very difficult, my lord.
Lot of calculation.
Very well, my lord.
10th.
10th.
এটা দু লাইনের অর্ডার করে নাও। This is an appeal under section 37 of the Arbitration and Conciliation Act, 1996. Stop. Mr. Tiwari, learned advocate appearing for the respondents, learned senior advocate, very sorry, says that this appeal requires admission under the provisions of Order 41, Rule 11, CPC. Stop. He cites rule.
Chapter 5, Rule 17A and 17B.
Chapter Roman 5, Rule 17 capital A and 17 capital B of the appellate side rules of this court, as also judgments
Reported at 2003, Volume 4, CHN 275, Anup Kumar Biswas and others versus Babul Kumar Biswas, and 2003, Volume 3, CHN 326, Abu Tahir versus Masammat Marjina Bibi.
Stop. Paragraph, Mr. Sen, learned senior advocate appearing for the appellant, seeks a little time to consider the judgments. Stop. Paragraph, since we are 2 days away from the summer vacation, this matter immediately upon reopening of court, on June 10.
একদম সব matter item number 10.
You are for the appellant? Dismissed. They were not there in the first call also. Usual, Abhijit. Appearance near now. Your original side.
Grateful man.
আজকে আসবেই না প্রণীত বোধহয় বিদেশে বেড়াতে ছিল কেন ও বললো অনলাইন
কল করো
Original side commercial division.
commercial division কেন হবে?
Commercial. হ্যাঁ 49 item number 1.
I appeal that this is my appeal. This was on the last occasion taken up. The service was not complete. But now the service is complete. On the registrar has received it a few days back, and the private respondent has received it yesterday.
ground this adjournment was sought for and it was granted. My lord, on 16th of April as well as on 5th of May. As well as I understand, my lord, the junior is the person who is not well. The senior counsel was there yesterday. My lord, I am not coming in the way, but
Senior counsel who's appearing?
my lord, I don't know, my lord.
Mr.
Only-
Jishnu, no,
No, we are for the appellant. In this suit,
do was 16th April, 5th May,
yes, my lord.
both dates adjournment. So is he likely to come tomorrow or day after tomorrow?
Day after tomorrow, maybe,
But
sir.
my lord, commercial division matters will be taken up tomorrow, not day after tomorrow.
Not today, we'll say what else. Accommodation is sought for on behalf of the respondents. Stop. Let the matter stand adjourned for the day.
Same
Again, accommodation is sought for the health ground.
Yes.
You're the appellant.
I'm the appellant.
So tomorrow will you do it or shall we keep it again? Tomorrow we don't know whether they will come or not.
Yesterday.
Not tomorrow.
Well, I don't think I should oppose because we've never been with an interim order.
Oh.
And I'm asking for an interim order now. So
Accommodation is sought for. লিখেছো এটা? তারপরে the second sentence টা কেটে দাও. Since we are only 2 days away from the summer vacation, let this matter be listed
reopening day, Milord, I'll come and pray.
on the reopening day, i.e. on June 9.
Milord, may I? One indulgence, Milord. I'm not praying for your lordship to record that in the order, but let it be understood. On that day, Milord, they shouldn't ask for an adjournment and we'll press him.
You make your learned friend understand why telling us.
Reopening day আমি order চাইবো।
হ্যাঁ, ঠিক আছে।
ঠিক আছে।
Will you give that order? He'll ask for the order.
Give the order. You will give the.
All right.
Perfectly said. Beautiful, Milord.
এই এসি চলছে না ভাই?
Yes.
না কি চলছে? সেন্ট্রাল এসিটা কি হলো?
Some Milord, problem with the electricity connection. Escalators are also not working. So yes, on the 9th matter will come. And then they'll come and press for order.
9 July.
9 June.
9 June.
9 June. In my present condition, it looks similar.
Item number 4.
Four similar matter.
Ah.
4, 5.
3, 4, and 5.
4, 5. 4, 5. 4, 5.
4 and 5 similar matter, similar order. Separate.
Item number 6. This is my appeal. To appeal on behalf of a tenant against a order.
How much money will you put in? Immediately.
I have taken some instruction, but on merits, I had some legal points. If you
We will hear you on merit.
allow me, then I will
Show your bona fides.
Lordship, I have taken an instruction. Since it has fallen from your Lordship, I have taken a written instruction. Their claim is that rent per month is 1,09,000. So what my client has given an email to my advocate record saying that from this month, he will continue go on paying the current rate of rent. And the arrears, he will try to pay it off by paying 2 months rent from the month of August. That is what the proposal is. He will continue the actual rent payment from 1,09,000 from this month, and from August he will clear the arrears by paying 2 months rent every month.
How much arrears is there?
Because they are claiming arrears from November 2019.
Yes.
No, not an admission.
How much it has
Obviously,
come
it's an
to? How
admission.
much?
Over 60 lakhs.
Over 60 lakhs. You better make your submission on merits. Let us decide it.
Lordship, that's the proposal that's a written instruction which I have got. Another proposal has also been given. We have a property at Amtola which we are willing to secure with them if they want at all.
What will be the do with your property?
No, that's a money claim is secured. If the money claims they actually become successful in the suit, then they can recover it by enforcing the.
Just allow us to go through the order once.
Yes.
Obviously, it's an eviction suit. It's an eviction
Eviction
suit. Yes.
Your Lordship will kindly take page 26. This is the reasoning given for granting this order of injunction.
We have read the order. Yes.
Para 26, what has persuaded the learned trial court is that there is an admission of payment at paragraph 5BB of my affidavit. So, injunction application allowed on the principles of judgment upon admission. Says that there is an admission. I have not admitted my liability of payment. I have only stated a fact. As per the agreement, the lease rent was 1,09,000 per month. That is the only statement which I made. There is no admission that I will pay the money. Kindly take the pleadings at paragraph 5BB, which the learned trial judge has relied upon. Kindly take, Your Lordship, volume 2, page 299. Lordship will take page 3. Oh, Your Lordship has not noticed, sir. Volume 2, page 310. Volume 3. এখানে ভুল আছে না না ইনজাংশন দিতে পারবে
Yes, we have seen.
Yes, Your Lordship. It is pertinent to note that the said monthly tenant of the suit premises was enhanced to 1,09,000 from the previous monthly rent. So this is what the learned has persuaded the judge. There is an admission of fact. Your Lordship, there is no admission of liability. I am saying that this was the rent which he is claiming per month. I have not said that I am liable to pay this money. So this is on this basis the injunction order has been passed.
Injunction.
Application was in the nature of injunction for temporary injunction for payment. Your Lordship will kindly take their application, page 172, volume 2, what they have prayed for. এখানে ইনজংশনটা বলেছে 172, Your Lordship.
What shop, what business do you do?
Your Lordship, I run a salon.
Salwar.
Salon, hair salon. Your Lordship will take page 183, para 9, their pleadings, on which basis they have made this prayer. Page 183, para 9. Entitled to claim an order of temporary injunction, directing the respondent to pay a monthly sum of rupees 1,09,000. And prayer portion, Your Lordship will kindly take their prayer at page 186.
Yes.
A direction upon the respondent to pay monthly sum of rupees 1,09,250 to the petitioner and to deposit the sum with the Honorable Court on and from September 2019 till such time the respondent hands over the physical and vacant possession. So this prayer is in the nature of injunction. Now kindly see their prayers in the plaint. My specific contention, Your Lordship, in the AO, because the learned trial judge has relied upon para 5BB of my affidavit in opposition, but has not taken the other legal contentions which I have taken. Now, Lordship will kindly take their prayer in the plaint. They have quantified their monetary claim and the damages. Page 47 is the prayer, volume 1. 46 it starts. First prayer, Your Lordship, for eviction. Second prayer, page 47, is for a decree for a sum of rupees 10,59,575 towards the payment of the defendant's share of municipal rates and taxes. C, decree for payment of municipal rates and taxes at the rate of 50% of the amount. Then D, decree for mean profit at the rate of rupees 1,50,000 per month. They consciously, while praying for eviction, has also quantified their monetary claim in the nature of damages and the mean profit. Mean profit is on the ground that I am illegally carrying on my business, and the profit which I am earning, I am liable to pay the money. This relief they are only entitled to once the final decree of eviction is passed. Now, a person who has quantified his monetary claim, which is subject to adjudication obviously after trial, cannot seek an order of injunction for payment of money, because that defeats the very principles of the
Yes.
That defeats the principles of injunction. Your Lordship knows very well that when there is irreparable loss,
right.
then only injunction can be granted if Your Lordship knows that there is a monetary claim, it can be quantified.
Next point. Next point.
Is Your Lordship coming to that? Your Lordship, I was only relying upon 41H of this 41H of the Specific Relief Act.
No injunction has been granted.
Injunction in the nature of payment of money. Your Lordship, the prayer is for temporary injunction.
Very well, very well.
The prayer is for temporary injunction.
Next point.
Your Lordship, on that issue, I will rely upon 2 judgments. And before that, Your Lordship, I had a Order 7 Rule 11 application pending, which was filed in the month of December 2024. Without deciding that application, we have challenging the maintainability of the suit. This injunction has been granted. Now, my contention is that the Order 7 Rule 11 maintainability point should be decided first. There is a checkered history to this matter. Initially, I as a tenant filed a suit in 2019 for protection of my right as a tenant.
The suit was filed in July 2021.
No, that is the landlord suit. I filed earlier a suit for protection of my right as a tenant. I got an order of
injunction. I'm not on that. Your Order 7 Rule 11 came in December 2024.
Correct.
After 3.5 years. Obviously an afterthought, because if your client thought your client had a case, wouldn't wait for 3.5 years to file a demurrer application.
Your Lordship, it's obviously what Your Lordship has said correct. Your Lordship, it's a point of law, Your Lordship.
Yes, sure. We'll deal with all your points. Tell us, what was your prior suit? Declaration. What happened to that suit?
That suit is pending. I have got an order of injunction not to be evicted without due process.
Which court?
City Civil Court. They are contesting that. They have filed the written statement.
You are protected. You are protected.
With regard to eviction, he is protected. I have also filed an application under Section 10 before this court. That was heard and it was reserved for order. Still date, no order has been passed.
I see. That was a prior suit. Your suit is a prior suit.
My suit is a prior suit. And the learned court at that point of time passed an order that without deciding those applications, without deciding my Section 10, because if the suit is stayed, then no other proceedings can be continued with. Even the injunction application cannot be heard. So an order was passed to that extent. By justice.
Trial of the suit will be stayed. We are not sure about your other proposition that nothing else can be
So there's
heard.
an order that no applications will be heard. There's an order is there. Judicial order to that effect is there. But anyways, I'm not going into that, but there is an application pending. It has been reserved for orders. Now, my contention is that this order 711 in my humble submission, because I relied upon a judgment which came subsequent to the filing of the suit of the landlord, passed by Justice Shobbhashaji Bhattacharya, saying that if there is no agreement between the parties and the dispute arises out of a mere breach under section 106 notice, that cannot be a commercial suit. This judgment came later on after the suit has been filed by the landlord. So I relied upon that judgment and filed an application for order 711. My specific contention is that without deciding the point of maintainability, no further orders can be passed in this suit in any injunction application. Your Lordship, on that proposition, Your Lordship will kindly allow me to place one judgment of the Supreme Court, recent judgment of the Supreme Court. It's 2024, volume 4 SCC 696. Para 50 and 52. Report is there. 2024 volume 4 SCC 6 times. 96. So although, if I may allowed to place the relevant paragraph, para 50, although not directly arising in the present case, we also wish to observe that the question of jurisdiction would assume importance even at the stage a court considers the question of grant of interim relief, where interim relief is claimed in a suit before a civil court, and the party to be affected by grant of such relief or any other party to the suit raises a point of maintainability, the roof thereof, or that it is barred by law, and also contends on that basis that interim relief should not be granted, the grant of interim relief in whatever form, if at all, ought to be preceded by formation and recording of at least prima facie satisfaction that the suit is maintainable or that it is not barred by law. Such a satisfaction resisting on appreciation of the averments made in the plaint and the application for interim relief and the written objection thereto, as well as relevant law that is cited in support of the objection, would be a part of the court reasoning of a prima facie case. 52. The legal and factual position of the present case having been noted above, we hold that the decision rendered by the court on the merits of a controversy in favor of the plaintiff without first adjudicating on it competence to decide such controversy would amount to a decision being rendered on an illegal and erroneous assumption of jurisdiction, and thus be assailable as lacking in inherent jurisdiction and treated as a nullity in the eye of law. Lordship, to this point, my learned friend will argue, when he will get it opportunity, that earlier in 2020, they earlier filed a suit in the commercial division. At that point of time, this Deepak Polymer judgment did not came in 2021. I took a point that the suit has to be filed in the non-commercial division because the suit has to be dismissed because 12A leave has not been taken. Now, when I took this legal point, by learned that that point of time they were not there, some other set of advocates were there. They came and withdrew the suit, and they filed in the commercial division. Now, subsequently, this judgment has came in. So I have taken advantage of the judgment that this is the now the correct legal proposition declared. So this cannot be a commercial suit, it's a 106 breach notice. So there is no agreement between the parties, should be sent to the commercial division.
So you had earlier contended that it has to be a commercial suit.
Because the property was being used for commercial.
And now you are contending it cannot be a commercial.
Because the judgment came later on. So I have relied upon that judgment and made this application. So it's the legal proposition which I have relied upon. So obviously they will say that my submission amounted an estoppel, so I cannot take this one later on. But your Lordship knows that there cannot be an estoppel against law. I can take advantage of a judgment which has
But
been
you
passed.
can continue to occupy without making any payment.
No, I will make payment, Your Lordship.
Bill is in futuro.
No, from this month.
Arrear.
From this month, Your Lordship, I will.
Arrear.
Arrear also, I will persuade my client to pay from this month only.
No question of you persuading your client. Lawyer's job is not to persuade client to pay.
Your Lordship, what to do? Because I have tried.
You will argue your case.
What
That
has
is
fallen,
it. Yes, you will
fallen
argue.
from Your Lordship, I have conveyed that you have to pay money.
Any other
to the
point?
bona fide. Yes, Your Lordship. Your Lordship, with regard to the point that or any order in the nature of injunction for payment of money cannot be granted when the parties have already quantified their claim. So there cannot be an irreparable loss for which injunction is granted, cannot be granted. So Lordship will be, there is a division bench judgment, if Your Lordship kindly allows me to rely upon, is 2009, volume 2 CLJ, Calcutta 301. Lordship, the paragraph numbers are bit marked. Your Lordship will kindly excuse me for that. Only the paragraph numbers, sir. Your Lordship will excuse
Paragraph
me.
numbers?
Paragraph numbers have been mentioned. Your Lordship will excuse me for that. On the top. Oh, is there in the other copy?
What para?
Your Lordship will kindly take para 17 onwards.
22 and 28.
Two 2009 to CLJ 301. Paragraph 17 onwards. In the case before us, the plaintiff has described the defendant number 3 as a trespasser and has paid for recovery of possession and also for mean profit as a final relief in the suit. In the application for temporary injunction, although the plaintiff prayed for injunction, restraining the defendants from entering the suit property, such prayer was not made before us, and the learned counsel for the appellant pressed for passing order for direction upon the defendant number 3 to direct occupational charges in the mandatory form as an interim measure. So similar prayer made herein as well. Then Your Lordship will take 20. Therefore, the mere fact that in the event the suit succeeds in the long run, the defendant number 3 would be required to pay a huge amount of mean profit is no ground to pass an order of mandatory injunction, disturbing the possession of the defendant during the pendency. If that be the position, there is also no ground for passing a direction upon the defendant by way of mandatory injunction to deposit any amount of money as occupational charges as condition for a stay by way of security, because there cannot be any mandatory injunction for payment of money by temporary measure even before passing of the decree for mean profit. The injury being not irreparable and being capable of being compensated in terms of money, therefore, in the facts of the present case, there is no scope for grant of any temporary mandatory injunction within the ambit of Order 39, Rule 1 and 2 of the Code as paid for by the plaintiff. Then para 26. Secondly, it appears from the decision in the case of Purushottam Das Bangur that in that case no proposition of law was laid down as to whether it is suit for eviction of a tenant if the tenant encroaches the property of the landlord, which is not the subject matter of the tenancy. A court dealing with such suit can, in addition to any amount equivalent to the rent last paid by the tenant in terms of the West Bengal Premises Tenancy Act, can direct the tenant to deposit such other amount of occupation which according to the landlord is not even the subject matter of tenancy. The lordship simply passed the direction by keeping all points open. It is now a settled law that a decision is only an authority for which it actually decides. What is the essence of the decision in its ratio is not every observation found therein, or nor what logically follows. Then para 27. It is therefore in the case of Purushottam Das, the apex court, for doing complete justice within the parties' excess power, we therefore hold that in a suit for eviction and mean profit against an alleged trespasser, there is no scope for passing an interim order in terms of Order 39 to direct the defendant to pay any amount of money as occupational charges as a condition staying. Actually, this is also a similar relief. Injunction for payment of money, the nature of mandatory relief, when they have already quantified for damages and mean profit. So the division bench in this judgment is saying that cannot be granted because this can be compensated money. It's not an irreparable loss. So there cannot be any injunction granted. The order, though the word injunction has not been used, but it is in the essence of a mandatory order to pay money. And that can only be granted, Your Lordship, under Section 39 of the Specific Relief Act. Your Lordship, the next judgment is a Supreme Court judgment, it's 2012, Volume 6, SCC 792. এটা আমার কাছে নেই বেস সেলের জাজমেন্টের প্যারাটা কি আমার কাছে নেই আমার কাছে কপি নেই ভিডিও কাজ বলছি But Your Lordship, I also had one copy which I have handed over. I also do not have a copy to assist Your Lordship. I have handed over. Very sorry, Your Lordship. This is also on the same principles. That no mandatory injunction in the nature of judgment. Lordship, this is also on that principles. And the paragraph number has also been given, Your Lordship. The best
29 to 37. একটাই কপি আছে বলছে 29 to 30.
Best seller. That was a famous there.
এটা ঠিক আছে এটা
কপিটাই তো দিয়ে জিরো থ্রিটা বের করছি 03টা
এখানে তো Supreme Court. Yes.
Yes. Lordship will kindly take the specific pleadings which I have made, because the learned single judge has also only chosen to rely upon one paragraph of my affidavit, which they have shown obviously they are not present. That's why we could not place the matter on merits, our defense on merits. Your Lordship will kindly come to page 302, volume 3, para G. I state that the reliefs as paid for in the suit cannot be granted in the form of mandatory injunction for payment of monthly rental amount of such and such should be deposited with the Honorable Court till the respondent hands over. I state that such relief in the form of mandatory injunction cannot be granted for in the interim application, as because mandatory injunction can only be granted only when there is loss is irreparable and cannot be compensated in terms of money. The moment a sum is due and quantified, then a mandatory injunction in the form of injunction cannot be granted as because it is beyond the principles of granting injunction as mentioned in specific relief act. So this point I have specifically taken, but we could not place it because for our fault, we admit that. I was not present, my junior was also not present, we could not place the matter on merits. But we have taken these legal points. Another point which we have taken, obviously this is subject to proof in the trial, that is there was a arrangement entered into, because this was during the COVID period. Your Lordship will kindly take paragraph 5Y, page 309. Arrangement was entered into between the parties that there will be a moratorium for payment of rent. At that point of time, Your Lordship knows there was no business. So they were also kind enough to give this moratorium. 5Y, page 309. In the beginning of 2020, due to corona scare in the city, followed by the pandemic and lockdown on business, could not be run and the business was totally shut down by the respondent between January to October 2020. In this connection, a joint meeting was held with the petitioner and the respondent at Parijat Housing Society that at their office that during the period no rent shall be payable due to the closure of business. This is obviously subject to proof. But all these facts I wanted to place on merits, but we could not. Your Lordship, I will show some of the orders which has been passed during the course of the hearing in the GA1 application. Your Lordship will kindly take first page 405, volume 3 itself. Obviously, they will show these orders and will try to say that we have taken adjournment, but that is not the fact. November, page 405. Your Lordship has got it. Mr. Thakkar, learned counsel appearing for the plaintiff, Tariq Banerjee, advocate appearing for the defendant. The counsel for the plaintiff has completed their argument in GA1 with regard to an order against the defendant for depositing the occupational charges. Learned counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. So it's not that I was shying away. I also made arguments at length on that date. Then, Your Lordship, page 407. December 9, at the prayer of the counsel for the defendant, the case is adjourned. Now, Your Lordship, this case was adjourned. I will tell you, Lordship, why. Because earlier, Justice Shobbashachi Chaudhary has taken a view that 106 breach, it cannot be a commercial suit. Justice Krishna Rao subsequently has taken a different view that no, even if there is a 106 breach, it will be a commercial suit. And the issue has been now referred to a larger bench. And I believe that is still pending. Mr. Arindo Mitra was appointed as the amicus curiae. He was arguing. I have taken the point that since this issue is pending, kindly don't decide the matter as on date. My GA7, the order 7 application, kindly adjourn the matter till the larger issue decides. So on that ground, the matter was adjourned. Now kindly take the next order at page 418, 16 December 2024. Kindly take from the third paragraph. The defendant has filed an application being GA-6, praying for rejection of the plaint. Counsel of the plaintiff submits that they will not use affidavit in opposition, and counsel for the plaintiff has argued the matter by relying upon the order passed by a coordinate bench of this court in GA4 in connection with such and such. Counsel for the defendant pressed time to place on record the judgment of the Honorable Supreme Court on the next date to establish the contention raised by the defendant. I have taken time on the ground because I wanted to place those judgment which says that if maintainability point has been taken first, that should be decided without hearing the other applications pending in the suit. So on that date, the petition was adjourned because of that.
These orders, Mr. Banerjee, not necessary.
So I am showing this because they will show these orders and say that I have taken time.
That's all right. All right.
I wanted to show.
Whether you took time or not is not really.
Now on 24th of January, what happened when the matter appeared? I have filed a petition to that effect. I will show. I personally, due to my family medical emergency, could not come to court. My junior was there, engaged on legs before the competent authority, and I have got those documents to show. And my advocate also did not come to court because of mother's illness. Genuine grounds.
You should have approached the learned judge with.
I have. Now recalling application filed, I have annexed that. Recalling application also dismissed.
Oh, yes.
From that, appeal has been preferred, which is item number 7. Because on that date, my learned friend said that no appeal has been preferred. Your Lordship was kind enough to give me time. I said that I am preferring an appeal. So Lordship was kind enough to give me time. In that meantime, I have preferred an appeal. So on those grounds, Your Lordship will kindly, if Your Lordship wants, I can show those grounds which I have taken in the recalling application.
Not necessary.
That because of personal reasons, I could not appear in court. Now, on 24th of January, when the order was being passed.
There may have been sufficient cause for you to not appear. We grant you that. But we are on the merits.
Yes. Your Lordship decides this here, or Your Lordship will kindly grant me a chance so that I can place my case on merits and decide it on any day. No, Your Lordship. No, no, if your lordship wants that this matter can be remanded, but your lordship can decide it here and now. I have no problem. Lordship will decide it here and now. Now, with regard to this, these are my submissions, your lordship. Now, if my learned friends.
Let us hear him now for a little while.
Yes, your lordship.
Yes.
Lordship, only one thing, they have filed an execution petition for against that order. So that is pending.
Very well.
Just to bring it to the north.
My first submission, my lord, is that your lordships have.
If we dismiss your appeal, the execution will proceed. If we allow your appeal, then execution will go. Very simple.
First, your lordships will consider the conduct of this party before your lordships. Now, admittedly, he is a tenant. But admittedly, as your lordships have seen in that paragraph BB, the last paid rent as per the paragraph is that in October the last rent was paid at the agreed rate of 1,09,000. Now, my lord, the submission was made that there is no admission that he is a tenant. But, my lord, in the title suit before the learned city civil court itself, the basis is that I am a tenant who is continuing to pay rent at the agreed rate. I may kindly have the title suit at page 203 is the starting.
Sir, it has to. He's claiming declaration of tenancy.
So, my lord, the tenancy is not in dispute. The amount last paid and the rate is not in dispute. The fact that the last paid amount was in October, that is their case. We say that last paid was in August.
October 2019.
2019. We say August 2019 was the last rent paid. He says in his written statement that the last rent was paid in October.
November.
Or November 2019. Apologies. So that is the difference, my lord. The admission of tenancy as well as rent paid as well as the date when the rent was paid is admitted. Then, my lord, he says that if your lordship kindly considers the conduct, in 2020, we file a civil suit before the, my lord, the ordinary jurisdiction of this honorable court. They come and say that it should be filed in the commercial division. They filed an application, and on that submission, we withdrew our appeal with liberty to file in the commercial division. When we come to the commercial division in December 2024, as the lordships have seen, they file an application at the belated stage saying that this should go to the non-commercial division. So that is the conduct that only.
So your application is not for taking the plaint of the file under Order 7, Rule 11.
Yes,
it is.
Yes.
Because it's a commercial dispute.
It's non-commercial.
Because
now
of this
Not a commercial dispute.
Now the stand is that it's a non-commercial dispute.
We have the judgment.
Now, my lord, the
do you wish to file do you wish to cite any decision?
Yes, my lord. On that issue, that once a claim for mean profit is made, then no occupational charges can be paid. On that, my lord, a recent judgment of the division bench of this honorable court, as late as, my lord, April 2024. I wish to rely on that judgment, my lord. This is, my lord, 2024 SCC Online Calcutta 1178. Debonair Vanijya versus Ashrat Jahan.
Is which paragraphs?
My lord, the facts are set out, my lord, at paragraphs 2, 3, and 4. And, my lord, the question framed is at paragraph 30, if I may read that paragraph, my lord. Now, the question is whether the same principle can be applied to cases where a decree for eviction has not been passed, the suit is pending, and the lessee is in occupation of the premises. Then, my paragraph 31, the case of Atmaram Properties was primarily concerned with the terms and conditions which a court could impose while staying a decree for eviction under Order 41 Rule 5 3C of the Code of Civil Procedure, the decree holder, according to the code, enjoying a decree for eviction for the judgment debtor could not be deprived of the fruits of the decree. So, then paragraph 32, could interim mean profits or occupation charges be granted pending trial of a suit for eviction? This, my lord, is answered at paragraph 38, where the defense of the tenant or occupier is practically absent and the case of the plaintiff correspondingly very strong, the principle in Atmaram could be extended and applied to pending suits to award mean profits or occupation charges to the plaintiff. It is to be assumed in such a case that the wrongfulness of the occupation of the defendant or date of determination of the lease and the date from which the occupation of the defendant became wrongful is almost certain. The defendant may be directed to pay reasonable mean profits at such rate as determined by the court as an interim relief to the plaintiff, subject to its final determination at the time of passing of the decree. Application of the principle would depend on the facts and circumstances of each case. Then, my lord, paragraph 43, no, my lord, not 43, my lord, thereafter, my lord, the Honorable Second Judge, my lord, differed on other points, but paragraph 90 of the dissenting order, thus considering the defense of the defendants, no, my lord, not 90, apologize, my lord. Paragraph 97. 96. On the following questions of law, there is unanimity between us. The principle on which mean profits or occupation charges can be directed to be paid to the plaintiff pending appeal from defendant against an order for, as laid down in Atmana properties would also apply in case of suits for eviction against occupiers and mean profits pending trial. This is subject to the plaintiff establishing prima facie that the defendant has practically no defense to the claim of the plaintiff. The award of mean profits or occupation charges need not be based on market value of the property. It should only satisfy the test of reasonableness. In our opinion, this view is also compatible with the ratio enunciated in Steel Court Syndicate, Kanak Projects, KK Saha versus Ashok Agarwal, Saj Food Products, and Utpal Ghosh. And my lord, I am carrying judgments of Honorable Single Judge of this court, my lord, where a reasonable amount has been determined to be the last paid rent by the tenant.
Here there's an agreed rent. Here there is an agreed rent.
That is the case of the appellant before.
Very well. Issue.
My lord, one more point, my lord. The appellant before your lordships is the husband of my lord, the defendant in another suit where similar identical conduct was taken. And my lord, we are carrying judgments where ultimately eviction was granted and there was even direction for paying the arrears of rent.
That may not be
that
relevant
went up
here.
to appeal before your lordships, and my lord, the appeal was also dismissed, and again the order of the learned single judge was upheld that they have to be evicted and amounts have to be paid.
Very well. Issue.
Lordship, I believe the judgments which I have cited were not considered in this judgment.
Not considered?
In this judgment which your learned friend has placed, I believe.
Distinguish the judgments also.
Which judgment? Your judgment?
Punam
Punam
Justice
Kejriwal
Bhaskar
and the Supreme Court judgment, bestsellers.
Jurisdiction has to be
No.
decided first.
On the principles that
Injunction. Very
principles that it cannot be granted.
On the, I can distinguish the Punam Kejriwal judgment.
I believe
also,
after the decree of eviction was being passed.
The Punam Kejriwal also I can distinguish on facts. The Punam Kejriwal judgment which my learned friend relied upon.
Yes, tell us.
But the distinction is that in that case, the tenant was the husband of the defendant who was directed to pay the occupational charges. The case was that the wife made a statement that I have been deserted by my husband, who is the actual tenant, and I have also filed a case for protection of Women's Act. And my lord, the submission was that if I am directed to pay the mean profits, that will saddle me with additional burden. And on that ground, my lord, it was held that since there was no tenant and landlord relationship between the defendant number 3 in that case, on that ground, my lord, it was held that no occupation charges could be paid by the defendant number 3 in that case. Here, my lord, there is an admitted case of tenant landlord relationship, admitted case of rent paid. So totally inapplicable in that.
No, they were joint tenants.
This can't continue. He will say 2 words, he will say 1 word, he will say 2 words.
Then reply, Your Lordship. The joint tenants. The principles have been set down.
This appeal is directed against a judgment and order dated January 24, 2025, whereby, a learned judge of this court disposed of GA1 of 2021 being an application filed by the respondents herein who are the plaintiffs before the learned single judge. Stop. Paragraph. The brief facts germane for the purpose of the present proceedings are that the appellant claims to be a tenant, monthly tenant, under the respondents in respect of a shoproom, bracketed in, described as the suit premises, bracket closed, at Theatre Road. What is the address?
Shakespeare Sharoni, Your Honor. Shakespeare.
24A, 24 capital A, Shakespeare Sharoni, Kolkata. Stop. The respondents have filed a suit for recovery of possession of the suit premises from the appellant, which is registered as CS-COM 276 of 2024. Stop. It is inter alia the contention. It is inter alia, the contention of the respondents that the appellant herein last paid rent at the agreed rate in August 2019. Stop. Thereafter, the appellant has not paid a penny, but has been enjoying the suit premises wherefrom he runs a business. Stop. Accordingly, in GA1 of 2024, GA 2021, prayer গুলো কোথায় ছিল যেন? না, এটা না। In GA1 of 2021, the plaintiffs prayed for the following orders. Page 186, capital A, mark kora ache. A আর B টা দিয়ে দিল। Paragraph. On the day the matter was taken up for hearing by the learned single judge, nobody appeared for the defendant, bracket present appellant. Stop. The learned judge recorded in the order impugned herein that on November 18, 2024, learned counsel for the plaintiffs concluded his argument and the matter was fixed on December 9, 2024. Stop. On that date, learned counsel for the defendant prayed for time and the case was adjourned till January 9, 2025. Stop. On January 10, 2025, the matter was taken up for hearing, but nobody appeared on behalf of the defendant. Stop. The learned judge adjourned the matter till January 21, 2025. Stop. In the order dated January 10, 2025, the learned judge made it clear that on the next date, if the defendant failed to appear, appropriate orders will be passed. Stop. Paragraph. On January 24, 2025. The matter was finally taken up for hearing and disposal. Stop. Nobody appeared for the defendant on that date also. Stop. The learned judge disposed of the application by passing the impugned order, the operative portion whereof reads as follows. Memorandum e achi impugned order ta internal page 2 or 3 থেকে set out করে দেবে। Paragraph. As would appear from the aforesaid order, learned counsel for the defendant went before the learned judge at the time of the order being dictated. Stop. However, the learned judge declined to adjourn the matter, noting that time and again the defendant had obtained adjournment. Stop. Being aggrieved, the defendant has come up by way of this appeal. Paragraph. Appearing for the appellant, Mr. Aurik Banerjee, learned advocate, has argued that Section 41. All injunction. You will learn. Oto is connected with the maintainability. Learned advocate, has argued, firstly, that the learned judge ought not to have passed a direction for deposit of money. Stop. The order was in the nature of a mandatory injunction, which, in view of the fact that the plaintiff has claimed damages / mean profits in the suit, ought not to have been passed. Stop. Mr. Banerjee drew our attention to section 41 H bracketed choto h of the specific relief act. Stop. Mr. Banerjee has also relied on a decision of the Honorable Supreme Court in the in the case of it bestsellers, na? Principle injunction temporary bestseller. Honorable Supreme Court এইটা ঠিক আছে, নামটা দিয়ে দেবেন, দিয়ে দিচ্ছি আমি, দিয়ে দেবো এই কাগজটা। হ্যাঁ, reported at 2012 6 SCC 792 to argue that grounds for passing an order of injunction, whether prohibitory or mandatory, do not exist in the present case. Stop. Learned counsel has also referred to a decision of a coordinate bench of this court in the case of Poonam Kejriwal, etc. এখান থেকে cause title নিয়ে নিও, reported at 2009 bracketed 2 CLJ bracketed Cal 301. In support of his contention that no mandatory injunction can be passed directing a defendant in an eviction suit to put in money on account of occupational charge during pendency of the suit. Stop. Paragraph. Mr. Banerjee then argued that the suit does not involve commercial dispute. Stop. It is not maintainable in the commercial division of this court. Stop. The appellant has filed an application under Order 7, Rule 11, CPC, for rejection of the plaint. Stop. Without first deciding such application, comma, the learned single judge ought not to have granted, ought not to have passed any interim order in favor of the plaintiffs. Stop. In this connection, learned counsel also referred to a decision of the Honorable Supreme Court in the case of Asma Latif, etc. পুরোটা দিয়ে দেবে, reported at 2024 4 SCC 696 in support of his contention that when the defendant oblique respondent to a proceeding raises a question of lack of jurisdiction of the court to entertain the LIS, comma, without first deciding that issue, comma, the court should not pass any order pertaining to the merits of the case. Stop. Mr. Banerjee, these were the points basically that you argued?
Yes.
We have covered, paragraph. We have also heard Mr. Your full name, sir?
Kanishk Kejriwal.
Mr. Kejriwal, comma.
Stay of suit I have also. That point I've taken.
Which
That
one?
Application for stay of
That
suit
is pending also. That is pending.
and reserve for judgment. Reserve for judgment.
আরেকটা প্যারাগ্রাফ অ্যাড করে দাও মিস্টার কেজরিওয়ালের আগে আরেকটা প্যারাগ্রাফ অ্যাড করো Mr. Banerjee further submitted that the appellant filed a suit in the City Civil Court in the year 2019 claiming declaration of tenancy and other consequential reliefs against the present plaintiffs. Stop. That suit is pending. Stop. An interim order of injunction is operating in that suit, protecting the present appellant from unlawful eviction, unlawful disposition. Stop. In view of that prior suit, comma, the appellant herein has filed a suit, filed an application under Section 10 CPC before the learned single judge in the present suit for stay of the trial of the suit. Stop. Hearing in that application has been concluded and judgment is reserved. Stop. Without first disposing of that application, comma, the learned judge ought not to have passed the impugned order. Next. We have also heard Mr. Kejriwal, comma, learned advocate appearing for the respondents, oblique plaintiffs. Stop. He says that the conduct of the appellant has been abysmal. Stop. Although the appellant admits in pleadings filed before the learned single judge that occupational charge in respect of the suit premises has been increased to 1,09,000, 1,09,000.
250. 109,250.
250 with effect from
With effect from
1,09,250, huh? With effect from blank, comma, since September, 2019, the appellant has not paid a penny to the respondents / landlords, whether at the old rate or at the revised rate. Stop. Learned Counsel further says that earlier the present plaintiffs had filed a suit in this court for eviction of the present appellant. Stop. The appellant, the appellant took a point that the suit ought to have been filed in the commercial division since the suit premises is being used exclusively for commercial purpose. Stop. Faced with such objection, the plaintiffs had withdrawn that suit and had then instituted the present suit in the commercial division. Stop. Now, the appellant is taking a diametrically opposite stand and saying that the suit does not lie in the commercial division. Stop. This also indicates the malafide of the appellant. Stop. Paragraph. We have considered the rival contentions of the parties. Stop. Paragraph. Insofar as the question of the learned judge being obliged to decide the issue of maintainability of the suit is concerned, issue of jurisdiction, issue of jurisdiction, is concerned, we note that presently, insofar as this court is concerned, there are two views. Stop. One learned judge, bracket naam diye do, naam de do. Yes, sir. The language judge naam de do. Do you have the two decisions of Justice Bhattacharya and Justice Krishna Rao? No.
Must be having. I can forward it. This one is Deepak Polymer and another is T. Thompson.
Acha.
Deepak Polymer.
Which
Delivered
judge?
by Justice Subhoshaji Bhattacharya.
One learned judge in the case of Deepak
Polymer.
Polymer.
Yes, I have that judge. This is the judge.
Deepak Polymers Private Limited reported at 2020 AI at 2021 SCC Online Cal 4323. In which it has been held,
This is the other judge.
That a dispute arising out of refusal by the defendants to comply with notices issued by the lessor under Section 106 of the Transfer of Property Act, 1882, is based on a statutory right independent of any clause of the lease agreement, and as such the same would not come within the meaning of commercial dispute as defined in section কত যেন? Section 2, bracket A1, bracket C, choto c, of the Commercial Courts Act. Stop. However, it appears that you have the other decision, Krishna Rao.
Page 8 minute is discussed.
By this, it has been referred to larger bench by this judge.
However, another learned judge, in the case of T.E. Thompson and Company Limited, bracket CS, bracket com, bracket close, number 4 of 2023, reported at 2024 SCC Online Cal 8985, has differed from the aforesaid view and has referred the issue to a larger bench before which the issue is pending. Stop. Paragraph. In view of the aforesaid, it was not unreasonable on the part of the learned single judge, who had in fact differed from the other learned judge, to not decide the issue of whether or not the present suit involves commercial dispute, immediately. Stop. We do not find we also notice the wavering stand of the appellant herein. Stop. Earlier, when the respondents herein had filed a suit in the non-commercial division of this court, the appellant had argued that the subject matter of the suit involved commercial dispute. Stop. Now, when the plaintiffs have presented the plaint in the commercial division, the appellant says it is a non-commercial dispute. Stop. Paragraph. We do not see now the facts of the case, the facts of the Supreme Court decision in Asma Latif, Asma Latif ekhane ache, Supra, were quite different. Stop. In that case, the defendants had raised the question of maintainability of the lists at the very outset. Stop. If a genuine question of maintainability of a proceeding is raised, then, of course, that issue should be decided first without any order, before passing any order. Before passing any order touching the merits of the case. Stop. However, we are of the opinion that the present objection of the appellant as to the maintainability of the suit in the commercial division is not bona fide and is an afterthought. Stop. Paragraph. We cannot countenance a situation where a person shall enjoy property belonging to another completely free of cost. Stop. While the respondents oblique plaintiffs say that the appellant herein paid rent oblique occupational charge last in the month of August 2019, the appellant oblique defendant says that he paid rent till November 2019. Stop. To avoid the controversy, the learned judge directed the appellant to deposit occupational charge from December 2019. Stop. The learned judge relied on an admission of the appellant in his affidavit in opposition filed in connection with GA1 of 2021, which has been extracted above as part of the impugned order. Stop. There indeed is a clear admission that the agreed rent oblique occupational charges was occupational charges was enhanced. Rent likho was enhanced to rupees 1,09,250. Stop. There is also an admission that the appellant paid rent to the respondents till November, 2019. Stop. It is, however, the appellant's contention that after that, the respondents refused to accept online payment of rent from the appellant. Stop. Paragraph. Be that as it may, it seems to be fairly clear and undisputed that since December 2019, the appellant has not paid a penny to the respondents, but continues to occupy the suit premises. Stop. This cannot be permitted. Stop. There is an agreed rent between the parties. Stop. The division bench judgment relied upon by the appellant is distinguishable. Stop. In that case, there was no agreement between the defendant who was asked to put in occupational charge, and the landlord. Stop. It was held that a trespasser could not be directed to put in occupational charge during the pendency of the suit without assessment of damages. Stop. Paragraph. In view of the aforesaid, we do not find any infirmity in the order of the learned single judge, which is sought to be assailed before us. Stop. It is a perfectly fair and lawful order. Stop. Paragraph. In view of the aforesaid, this appeal fails and is dismissed. ছোট করে করে দেবো সালসা for salsa. With costs assessed as rupees 10,000 to be paid, ওটা কি legal high court legal service authority না high court legal service authority within a week from date. Stop. এই ঠিক নামটা দেখে করে দিও স্টেট লিগাল সার্ভিস অথরিটি স্টেট লিগাল সার্ভিস অথরিটি a copy of this order shall be sent by the registry to the member secretary of the State Legal Service Authority. Stop. In the event the cost is not paid within the time period indicated herein, the member secretary shall draw the same to this court's attention. That's it.
Cost your lordship will kindly.
For a good cause. Running a salon on Theatre Road.
Running at a loss. That's why we are not able to pay.
Chalo.
One thing, my lord, your lordship
Second
have
appeal was from the order of recalling.
That is in
That becomes
infraction.
Your lordships had left a
Which is
blank.
that one? Next one?
Next.
Yes, what?
The rent escalation was from 1st July 2016. Your lordship
ও
had
একটা
left a
জায়গা with effect from blank ছিল
1st July 2016.
ওনাকে জিজ্ঞেস করে নিও ওটা হবে July 1
First, 2016.
2016 July 1, 2016 আরেকটা বলছে আছে কোনটা বলছে আর 3:30 হয়ে গেল চলে গেল হ্যাঁ নেক্সটটা নাও 7 যেটা 7
Lordship, I'll
একই তো infraction হয়
This appeal is directed against an order whereby the appellant's application for recall of an order dated
21st February 2025.
parent order
Parent order 24th January 2020.
January 24, 2025 কি বললাম order dated ওখানেও লেখো order dated February
24th January 2020.
এখানে লেখো February
21st 2025.
21, 2025 whereby was dismissed. Stop. Paragraph. Today itself, we have disposed of the appeal against the parent order dated January 24, 2025. Paragraph. Accordingly, nothing remains in this appeal, which is accordingly disposed of. Taco 330.
Lordship, I'll tender my unconditional apologies. Lordship, item number 10 of the appellate side. Lordship, I am for the appellant IOCL. Mr. Amit Kumar Nag is leading me. He is unwell, my lord, which is why he couldn't attend. It has been dismissed.
Hey, কৌশিক 10 নম্বর অ্যাপেলের সাইড যেটা বলছেন ডিসমিস ফর ডিফল্টটা ওটা অর্ডার করতে বারণ করে দাও বলে দাও নট টুডে করে রেখে দাও
Lordship, if it can be kept after vacation, Lordship, because he is not well, he will not be able to come. I'm grateful.
Fixed matter item number 24.
Mr. Sengupta, Mr. Ghosh, Mr. Bachawat,
yes,
we will have to rise at 4:15 because of administrative work. So you can start, or it's up to you.
Does your lordship have other urgent matters? If
No,
not,
no,
then
no.
in that case, কি করবো বলো?
You have about 25 minutes.
But I don't think the two of us can finish within that. It's
But
pointless.
then you wouldn't have finished even in 1 hour.
No, I'll take 10 minutes. I'll take 10 minutes, but not my learned friend.
So you can make some progress.
I'll do that. I'll do that. I'll do that. No, I'll do that. No, I'll just give you a lordship, not very short back.
Then we'll release the other matters.
The lordship could do that. The lordship. But a short point here is suit filed, not suit is for infringement and passing off, not leave under section 12A of the not Commercial Courts Act granted. Now the matter comes up 2.5 months later, they apply for revocation of not leave granted. Now leave is revoked. Leave is revoked on
You're the
basis.
plaintiff.
Yes, I'm for the plaintiff. Leave is revoked not on the basis that I'm supposed to have had deemed knowledge of something which has happened years ago, which is not mentioned in the plaint. This is the long
Krishi Mela.
Krishi Mela. Kishan Mela. Kisan Mela. Now, Milord, and that Kisan Mela, there were completely, Milord, two things. হ্যাঁ যাও 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 হ্যাঁ সব এক্সপার্টি করে চলে যাচ্ছি 30 সেকেন্ডে Now, what had happened was there was a Kisan Mela. We have annexed photographs of that. Now, from that, he pulls out a directory to show that he also participated in that Mela, but under a different name. He was not the present plaintiff's name is not to be found there. His name at that point of time was the Current Enterprises, not the present defendant. And he was in some other hall. Not how I'm supposed to have had deemed knowledge from the fact that in 2018, some directory he produces, I was also there in a fair. So this is one ground, there are two grounds the learned judge has gone on. He has proceeded on the basis of deemed knowledge for two reasons. Number one is this. Number two, there is a WhatsApp message, not exchange of WhatsApp messages, a whole lot of them, between one of my employees who is in charge of procurement of materials with someone selling all kinds of spare parts. So he makes an inquiry for spare parts and he sent a list of spare parts. One of those not spare parts refers to not his trademark. So not on that basis, I am supposed to have deemed knowledge. We showed a judgment saying the knowledge of an employee cannot be attributed to the company because not he is not a specialist in trademark. He is out procuring parts. He writes to someone asking for not spare parts to see what spare parts are available, and a list of not spare parts is sent to him. One of them is that. Now, on the basis of that, and that was in 2022, on the basis of that, again, Lord, the learned judge says that Lord, my knowledge is to be deemed, and Lord, on that basis, leave has been revoked. Now, this is the long and short of the factual position. Now, 4 points the learned judge has held in his judgment, not if your lordship sees. Number one, he has held that IP matters, not intellectual property matters. Now, I'll take your lordship in the judgment. It may be quicker if I just summarize it. Now, intellectual property matters stand on a different footing. Number two, he has also held, this is on the basis of a number of judgments which are there, not Delhi, Bombay, they follow that view. So, delay does not matter in such matters. Number two, infringement and passing off are continuing wrongs. So, there's a fresh cause of action, not with every act of infringement and passing off. He has not also accepted that proposition. Now, after accepting it, he says, he also accepts our argument that a application for revocation of leave under 12A is akin to a demurrer. In other words, whatever I've said in the plaint and the annexures, you have to take that. You can't rely on other matter. So my learned friend comes up with 500 pages to show that there was a Kisan Mela, a directory to show that he participated. So the Supreme Court judgment seems to indicate that it's in the nature of demurrer. The learned judge accepts it. Now, how could he have looked at all the other evidences outside of the plaint to come to this finding? So, this is also an issue that your lordship will look at. And, the finding is not that I had knowledge, not just deemed knowledge. One page I'll just show your lordship from the order. If your lordship comes to three critical paras over here. The Supreme Court judgment also, I'll just give your lordship so that we can keep it within a short compass. The Supreme Court in the leading judgment on this, not a case called not Yamini Manohar's case, not says that there is a very limited window in which leave may be revoked. That limited window being deception. If I have deceived the court at the point of time of taking leave, that seems to be the limited window. And what this judgment says is, number one, it's the plaintiff's suit. You have to judge the urgency from the point of view of the plaintiff. It is entirely his wish. If he says he seeks urgent relief, that is end of the matter. The only not exception or the word used is limited window is if not there is falsity and deception practiced. This is the only limited window. The learned judge accepts that. Now, after that, to base his finding on a sentence which I'll read out, it is true that at the point of time, the impugned mark belonged to Karan Enterprises, which is not the name of the defendant as it now stands, prior to the change in favor of defendant number one in July 2020. Now, please see the finding. However, this does not mean that the plaintiff could not have had knowledge. Now, can it be said there is falsity? No, I could have had knowledge if I looked at the directory, I would have found the name of Karan Enterprise. But it can't proceed on a presumption. It does not mean that the plaintiff could not have had any knowledge. This is the basis on which it's gone. Now, given this, I will not trouble your lordship too much with the judgments. The relevant parts are actually set out in the impugned judgment. If I could just take your lordship very quickly through it. But I will not trouble your lordship with their contentions, like I told your lordship, twofold. If your lordship comes to para 5 straight away, I won't trouble your lordship with the rest of the paras before that. On behalf of the defendants, it is contended that the plaintiffs were deliberately misrepresented and suppressed the true and correct facts as to the knowledge of the impugned mark. The plaintiffs were aware that the defendants had been selling goods under the impugned mark as far back as December 2018. Now, please mark the words, plaintiffs were aware. Not this as opposed to, could not be said that I could not have had knowledge. That's not the finding. This would be evident from the promotional material pertaining to an industrial trade for an exhibition Kisan Mela at Moshi, Pune, 12 to 16 December 2018. Documents relied on by the defendants indicate that the plaintiff had participated in the exhibition and had knowledge of the rival goods. Now, I don't know where he gets this. This is, of course, the submission, but knowledge is not found. I've showed your lordship, but it is deemed knowledge. Then, the defendants also, this is the other allegation, defendants also rely on a series of WhatsApp messages dated 9th March 2022, exchanged between an employee and the plaintiffs, which reveal that while in the service of the production management team of the plaintiffs, the said employee, now production management team, he is not salesperson, he is not a marketing person. The said employee had in the usual course of business dealt with and exchanged specific information pertaining to the products of the defendants being sold under the impugned mark. Accordingly, averments in the plaint that the plaintiff came to learn of the impugned mark in May 2024 is ex facie false and incorrect. Now, permit me to make one more comment here. This is not appearing from my plaint, so it can't be ex facie incorrect. He has relied on 5,000 pages of documents to show that there is a possibility I might have known that he was at the fair. Now, these are matters to be proved in the trial. Not that I'll show your lordship from the judgment. Then, my lord, please turn the page. The judgments are referred to. Lord, our submissions are recorded that I did not know. And Lord, if your lordship then turns the page, para 8 is not the act is set out. Then, my lord, Yamini Manohar, Supreme Court, para 9 is set out. Lord, I'll have to place that judgment in any case, but I'll give your lordship. We are of the opinion that when a plaint is filed under the Commercial Courts Act with a prayer for urgent interim relief, commercial court should examine the nature and subject matter of the suit. Lord, your lordship can mark that subject matter of the suit. Lord, in IP matters, it's been held to be on a slightly different footing. Lord, that's what Bombay and Delhi, that's how they've construed the cause of action and the prayers for interim relief. The prayer for urgent interim relief should not be a disguise or a mask to wriggle out of and get over Section 12A. Facts and circumstances of the of the case have to be considered holistically from the standpoint of the plaintiff. Non-grant of interim relief at the ad interim stage when the plaint is taken up for registration, admission, and examination will not justify dismissal of the commercial suit under Order 7, Rule 11. So, my lord, the fact that I may not get, my lord, the relief in a injunction application is not a justification for refusing grant under 12A. When the plaint is taken up, etc., then, my lord, at times, interim relief is granted after issuance of notice, nor can the suit be dismissed under Order 7, Rule 11 of the Code, because interim relief post the arguments is denied on the merits and on examination of the three principles, namely prima facie case, irreparable harm and injury, and balance of convenience. The fact that the court issued notice and or granted interim stay may indicate that the court is inclined to entertain the plaint. Now, my lord, in this case, interim order was granted. It had been there 2.5 months later when the matter is coming up for final hearing. This application under 12A was filed, and that's when it was heard. Then, but having stated so, it is difficult to agree with the proposition that the plaintiff has the absolute choice and the right to paralyze 12A of the Commercial Courts Act by making a prayer for urgent interim relief. Camouflage and guise to bypass the statutory mandate of the pre-litigation mediation should be checked when deception and falsity is apparent or established. Now, my lord, so, my lord, this deception and falsity must be apparent or established. Now, there is no, my lord, at this stage, at the stage of grant of leave, my lord, when it is granted, there is no possibility of your lordship having access to any other material in the at the point of time, my lord, when the leave is granted. Now, thereafter, my lord, my learned friend says he was there in a fair, I was there in a fair. Therefore, I must have had knowledge. Not there also, my lord, it can't fall within deception and falsity, which is apparent or established. Lord, it's a very high level. Lord, it must be established. The proposition that the commercial courts do have a role, albeit a limited one, should be accepted. So, my lord, very limited window. Otherwise, it would be up to the plaintiff alone to decide whether to resort to the procedure under Section 12A. An absolute and unfettered right approach is not justified, etc. Then, my lord, para 10, now, my lord, the findings in view of the above, there is limited scope for a court to examine the grounds for revocation of dispensation. Section 12 requirements of pre-institution mediation. 12A of the Act is imperative, and any suit which is instituted without following the mandate has to be necessarily rejected. This is no longer res indica, party law, automation, etc. But these judgments are there. Then, my lord, please turn the page. But from the top of the page, if I may read on, not from there, the plaintiff, though dominus litis, cannot escape the mandatory requirement of the Act. In order to seek dispensation with the requirement of pre-institution mediation and settlement, plaintiff must contemplate grant of urgent interim relief. So, the language used, it must contemplate it. That's all. Not it's the plaintiff's wish. Not if he says I contemplate it, that is generally good enough. This needs to be pleaded and must appear from the plaint along with the supporting facts and documentary evidence available to the court at that stage. Narrow compass in Yamini Manohar, which has been left open, are in those cases where the plaintiff seeks to artificially or falsely create urgency only to circumvent the requirement of pre-institution mediation or settlement. In cases where the request for urgent relief, as pleaded in the plaint, is not tainted nor artificial, ordinarily the courts must defer to the perception of the plaintiffs that there is need for urgent reliefs. A fortiori, there cannot be any deception, falsehood, or suppression in pleading. Urgency in order to obtain dispensation under Section 12A, etc. Then, there is no straitjacket formula. Each case depends on the facts of its case. It's true that the section does not provide for exemption in any category of suits, save and except those where the plaint contemplates urgent relief. Now, let's see the next few findings. Ordinarily, in intellectual property matters, keeping in mind the question of public interest, nature of rival rights or competing interests involved, the need for urgent interim reliefs is almost inevitable. However, this is not an inflexible rule nor an exception to the mandatory provision of the 12A of the Act. It is also true that the cause of action in such cases is recurring and continuing in nature. Nevertheless, Somladi also comes to a finding it's a continuing cause of action and recurring. Nevertheless, this has to be tested in the backdrop of when the right to sue arises. And Sundaram Finance's case is referred to. Mandatory obligation under 12A of the Act cannot be bypassed in a circuitous manner to render the same nugatory. Now, the crucial aspect which needs to be examined is the knowledge of the defendant's adoption and use of the mark really in the light of the averments in the plaint. Admittedly, the parties are trade rivals carrying on similar business. Now, my lord, I have been there from 1965. He starts under the name Karan Enterprises, lord, in 2018. 2000, and not as proposed to be used. That's his trademark application. He participates in a fair where this name is not there. Lord, thereafter, don't do fool. Your name was not there. Now, my learned friend on Facebook, I'll show your lordship the falsity. On Facebook, he shows his existence in 2018, and the name of not this company, the new company, is showing on the Facebook. Now, we show from the ROC website that the company name did not exist at that time. It did not exist. So I'll show that. Then the crucial aspect which needs to be examined is the knowledge of the defendant's adoption and use of the impugned mark really in the light of averments in the plaint. Admittedly, the parties are trade rivals carrying on similar business. Both are registered proprietors of their respective marks. It's also true that an exhibition, now, my lord, this is the finding, displaying the rival products in the same category of goods was held between 12 to 16 December at Moshi, Pune. This fact is also mentioned by the plaintiffs, but for a different purpose. The exhibition was attended by both parties. The goods being sold under the impugned mark were on display. It is true that at that point of time, the impugned mark belonged to Karan Enterprises prior to change in favor of the defendant number one in July 2020. So, my lord, he did not exist till July 2020. Yet, he's showing a Facebook page showing his existence not in 2018. I'll show that. However, this does not mean that the plaintiffs, now, my lord, this is the crucial sentence. However, this does not mean that the plaintiffs could not have had any knowledge of the existence of the mark here, which had already been launched and the products were available in the market. Now, my lord, look at the careful use of the double negative over here. He does not say, I have knowledge. It does not mean that I could not have had knowledge. In any event, the WhatsApp message is exchanged between an employee of the plaintiff and an authorized dealer. He is not my authorized dealer, for sure. Employee of the plaintiff and an authorized dealer express agrees seeking specific information and details of spare parts for agricultural machines which were being sold and imported by the defendants under the impugned mark is conclusive. Accordingly, now let's please see this. Accordingly, plaintiffs are deemed to have had knowledge of the impugned mark being in the market. Now, my lord, if it is only deemed knowledge, will it fall within that limited window in Yamini Manohar, deception and falsity? You must come to a conclusive finding that I knew about it. If I did not know about it, where is the question of there being any deception or falsity? It cannot fall within that limited window. The contention that the knowledge of an employee is not attributable to the plaintiffs is unsubstantiated and without basis. In this regard, decision of Apollo Tires is distinguishable. Not nothing given to distinguish it. It simply says distinguishable. In the said decision, the court had found that the facts which had been disclosed were trivial, inconsequential, and did not fundamentally alter the case. It was an exact, not similar case where, my lord, a employee of the plaintiff was found to have knowledge. He had full knowledge of the tires of Apollo, and it was held that the knowledge of an employee will not be attributed as knowledge of the company. In such circumstances, the assertion, not para 13, the assertion in the plaint of the plaintiffs having come to learn of the impugned product in May is patently false. Now, till there it was deemed knowledge. From deemed, not how can this become patently false? A party litigant cannot be indifferent and negligent in his duty to place all relevant records. Now, my lord, indifference and negligent is not a ground to revoke leave under 12A. Right? It is deception and falsity and nothing more and nothing less. To place relevant documents, material in support of its contention is bound to produce the same. One who comes to court must come with clean hands, non-mentioning and non-production of true and correct information relating to Kisan Mela or WhatsApp, tantamounts to material suppression and displaying fraud on the court. Now, my lord, if I may not put it this way, Lord, if I say that I did not have knowledge, Lord, how can I produce proof of that? The learned judge has himself gone on the basis of deemed knowledge. I also say, look, my employee may have, in sourcing materials, tried to not find out some message may have been sent, but the company did not have knowledge. Learned judge not perhaps accepts this because he says he's proceeding on deemed knowledge. Now, my lord, if it is deemed knowledge, there could not have been, my lord, suppression or falsity or deception, either of these three. And my lord, the learned judge then, my lord, goes on the basis of not playing fraud on court. Then, my lord, 14, both the above facts are material and germane on the aspect of knowledge of the impugned mark, and suppression thereof can only be with the aim of wriggling out of the requirements of the Act. And then, my lord, your lordship, my lord, sees he also accepts the other principle, para 16. It's true that in some ways the exercise undertaken by the court while examining the revocation with the requirement of pre-institution mediation and settlement is akin to hearing a demurrer application. Now, if it is akin to hearing a demurrer application, then you can't start looking at all these documents which he has produced. And these judgments are there. So, how does he get around it? So, after looking at these judgments, the next sentence, nevertheless, in light of the principle that fraud unravels all, any material fact or document which is alleged to have been suppressed can always be looked into by court to ascertain whether there has not been a fraud on court. Now, from deemed knowledge to hop to a conclusion of fraud, is a bit much. And the two judgments that he cited there were Delhi and Bombay judgments referred to in similar situation, not referred to over here. Then para 17, the ground that the plaintiffs, my learned friend had also argued that if there is more than 3 months delay in filing the suit, that is enough. The suit is, it's like not barred, it's like a period of limitation, because within that time you could have exhausted mediation. That is rejected in the next paragraph. The ground that the plaintiffs had waited for 5 months before filing of the suit, and this per se disentitles them to seek dispensation, is untenable and is rejected. He goes on to hold that this time gap will not matter.
What do you do, Mr. Mashavat? Tomorrow, day after, or after vacation? What do you do?
It doesn't make sense to.
He has not exhausted himself within 10.
When?
10th June, Lordship keeps it. Otherwise, if he is here, will not.
Follow.
10th June, will not.
Because it was like I said in the beginning, let's keep it other side of the vacation. Unless your lordship has.
Mr. Bachawat,
keep it after 12th.
After vacation. After 12th. Hey, কোনো আগের order আছে আগের দিনের?
আগের দিনে কোনো order আছে? Any time Lordship gives, sir, I'll try to finish.
Mr. Bachawat, Kamalar, senior advocate appearing for the appellants, begins his opening submission but does not conclude. Paragraph, we are 2 days away from the summer vacation, stop, as suggested by learned counsel for the parties, comma, list this matter once again on June.
Whatever date, except 9th, any date.
He says after 12th.
After 12th.
Would you like 13th? No.
Not make it 14th. 13th sounds unlucky.
13th is a Friday.
Wait, maybe unlucky to me. Not in that case, not make it there.
16. Thank you.
One more indulgence, Lordship, in item number 10, which I just mentioned a while ago. Lordship, Mr. Shatru Banerjee had appeared for the respondents. I've already informed Mr. Banerjee.
Yes.
I've already informed Mr. Great.